May please, Lordship. I beg to mention item number 9, pass over for the day, Lordship.
I pray that the date may be fixed.
Just a minute. Why do you want adjournment?
Senior not while
Who is the senior?
F.
Madam, you are for the
For the victim's father, madam. Who is
respondent number two. Okay.
9.
Mr. F. Huck, learned counsel for the appellant, is said to be in this post. On a mention made on his behalf and not objected to by the other side. That is the matter. In the month of March,
Like,
on a date to be fixed by the registry.
obliged.
Lordship, may I make a mention as regards item number 11 as partner matter? Lordship will kindly accommodate me till 2 o'clock. I need to attend the permission. My lord, I didn't come back. 11 partner matter, 2 o'clock I'll do.
2 o'clock.
He is for the other side. And same prayer is for item number 5 also, Lordship. I have looked up. At 2 it may be taken.
Then before 2 o'clock, what will we do here then?
As soon as I come back, Lordship, they are coming on their way. So I'll attend it, I'll go home and again come back.
Part hard and the other one is?
Item 5, if it reaches, it's okay, Your Lordship, kindly accommodate me. There are other matters also.
My lord, I am here, my lord. Moment my senior colleagues comes, my lord, I'll immediately. Because I only need to show the judgment.
My colleague's mother expired, Your Lordship, I need to.
Item 5 also, is it?
Yes, mine.
All right.
Any time, I'll go any more. Applies, Your Lordship.
May I please, Lordship? So I am praying for listing of a criminal appeal, my lord, which was last listed on 29/4/2025. As per earlier order, my lord, this matter was office was directed to list the matter for early hearing, my lord.
You approach the registry.
Monday, my lord.
You approach the registry for listing.
My lord,
Okay.
I have
Please approach again. All right.
obliged.
Late legal person, but I did mention for listing in the criminal appeal matter. So matter is pending in 2018 madam. One of the accused was died in the jail hospital. Another accused madam is seriously ill madam. They are two brothers in the jail hospital. So it will become madam next week immediately.
No, you also go to the registry for listing. All right.
There is a urgent urgency there.
May it please your lordship, begging for the adjournment of item number 10.
Yes. You're for the appellant.
Yes, no, petitioner.
This is an appeal. Item number 10 is a criminal appeal.
Yes, yes,
For the appeal, for the accused.
So you have to be either for the appellant or for the state.
for the appellant.
Why do you want adjournment?
My senior counsel is out of station for medical reasons.
Who is that?
Sabris Ahmed.
But other counsels are here. A. Hussain, Darak Nur.
Lordship, the brief is with him and he will argue the matter.
Okay, Mr. Sabrish Ahmed, who is said to be the lead counsel, is said to be in this,
Out of station.
is said to be out of station on personal ground. And therefore, a mention has been made on his behalf for adjournment. What about state, PP? Okay. Since the prayer is not opposed to by the opposite party, let the matter be listed in the month of March on a date to be fixed by the registry.
Obliged.
For orders,
Yes.
item 1.
One more. May I please your lordships? Lordship, I beg to mention item number 3 of daily list.
Yes.
Due to some personal difficulties, my senior is out of station, lordship. Kindly pass over
Who
for
is your senior?
MU Mahmood, lordship.
Appeal is of the year 2022. And what is this PI? Oh, so this is next different case.
Lordship, I don't have idea. Actually, he also filed a leave note.
Okay, Mr. M.U. Mahmood, learned counsel for the
Lordship,
appellant,
any date.
is
next
just a minute. He is said to be out of station. So it is also submitted that he has submitted leave of absence. And therefore, a prayer has been made by Miss
Yes, Sheikh.
S. Sheikh for adjournment of the case. Have you informed the other side?
Yes, Lordship.
The learned counsel submits that she has informed the learned counsels for the opposite party about the adjournment being sought. To stop in view of above, let the matter be listed for hearing in the month of March on a date to be fixed by the registry. Stop. The case appears to be of the year 2022, and therefore it is expected that further adjournment will not be sought on the next date. Yes.
Obliged, Lordship.
Item 1 for orders.
May I take a motion? Lordship, a matter has come up today for consideration of the IA for bail.
Actually, objection has not been filed by us, my lord.
IA. Where's the IA? This has come for the second time. IA.
Lordship, probably under last occasion.
Are you going to file or not? You'll file. When will you file?
Place for IAD and I am going to file it. Koriba na, IAD pa? Koriba.
How long will it take for filing IA?
Because on earlier occasion, 4 weeks time was granted.
Okay. Ms. B. Bhuyan, learned at least the additional PP, Assam, prays for and is granted further 2 weeks time to file objection to the IA. In view of above, list this matter again.
May I get a fixed date, my?
Give a date, 11 March.
Lordship, can it be on 12 or 13, Lordship? I will be out of station on 11.
12 March.
Item 2.
Lordship, here a report was called for as regards date of the informant. Lordship, although report has come, it doesn't contain any seal, my lord. The IO has only sent one date certificate.
My lord, I am behind the bar for 1 year, 7 months. Paper book is ready also.
What is the report of the IU?
Only send one date certificate.
It can
Death
be-
certificate.
Yes.
Whose,
It can be verified in the my lord site also, my lord.
no, whose death certificate is this?
Informant.
Oh, informant is not,
Naam to put. Babul Pator. His name is there, your lordship, page 2. Name of this is Babul Pator. But it doesn't contain any sign and seal, although name of the other, this one, wife's name is there, endorsement is there in the next page, my lord.
See this one series of.
Oh, I didn't find any seal.
on the top, left-hand side, top left-hand side. Joint Director of Health Services.
No, it's as regards dates, but IOS,
IOS.
IOS series.
You verify?
Lordship, can it be done, my lord? Notice may go to the victim, it's a POCSO matter. Or
This is the informant.
as he is no longer
Babul Patar is the informant,
father of the victim.
father of the victim.
Mother has signed it. Budheswari Pator. It's an Assamese man.
On the second page.
Yes, last page, Your Lordship.
So mother is aware about this appeal then?
Yes. It, Your Lordship, but it doesn't contain any seal of the, yes.
We can appoint somebody. No point sending again and again. Please write notice sent to respondent number 2 has returned back. From the office, from whom? Who has sent this?
We have written it to officer in charge Morigaon Police Station. He has sent via WhatsApp, my junior.
The second page is sent by that.
That IO only. Second and third page have been sent by IO.
Has returned back from the IO.
Yes.
That has returned back from the officer in charge of the police station concerned by enclosing a death certificate of the informant. Along with the signature of the mother of the victim. So under the circumstance, we are of the view that notice on respondent number 2 can be accepted. Stop. Further, instead of sending a fresh notice to the victim, we are of the view that an amicus be appointed to represent the respondent number 2. So accordingly, we appoint, who shall we appoint, brother? Supratim. Seriously. Sri Supratim Dev Prakyastha is appointed as the amicus curiae to represent the respondent number 2. Stop registry shall furnish a copy of the paper book to him within 3 days. And thereafter list this matter for hearing in the month of March on a date to be fixed by the registry
For hearing, my lord?
for hearing.
Lordship, may fix a date for hearing.
They will give a date.
Okay.
2025 matter. 25 matter.
Correct. See, so will not, they'll give a date.
I can go.
May it please your lordship. Lordship, my senior Mr. Kane Chaudhary is before the court number 1, your lordship. May this matter be taken up after some time.
PIL.
PIL, your.
Why is it listed before this bench?
Perhaps Justice J.D. Chaudhary could not take up the matter.
Take up the matter.
And matter relates to?
But if it relates to a calcination plan, the consent to establish of the calcination plan has been challenged by way of this PIL.
Cancellation?
Calcination plant, Lordship. It makes a product called calcined petroleum coke. It's a small industry. And the consent.
Calcination.
Calcination, Lordship.
Okay.
Calcination.
What does it do? Calcination plant?
Lordship, the product that is made is something called calcined petroleum coke, which is then used in aluminium and steel industries as an anode.
Okay.
The plant that is in question in this case, it makes CPC or calcined petroleum coke from a raw material called raw petroleum coke that is obtained from the refineries. They use that and subject it to a process called calcination, followed with CPC statement. For that, a consent to establish was granted to my client. I appear for the respondent 4, which is the company in question. That provision and consent.
Company was manufacturing that.
Yes.
Where is it?
In Amingaon, Lordship.
Amingaon.
The EPIB part. So that is the dispute in question.
So the petitioners are filed this PIL
Yes, sir.
to
challenging the CTC because it went beyond the mandate, Lordship.
CPC.
The consent to establish, Lordship, went beyond the mandate.
Who has
They
given the
used-
consent?
Lordship,
Who has given the consent?
PCB, Lordship, respondent number 2,
Pollution Control Board.
Pollution Control Board.
Okay.
So they went beyond the amended
So-
lordship, the initial consent to establish. was
You have
given-
challenged that consent
We have challenged the consent. Your lordship.
because it goes beyond the,
Mandate lordship, because it was initially allowed, then it was cancelled, and after a long years, again they approached and it was given backdated lordship. That is what we've challenged.
Chip, my difficulty is that there is a status quo order operating from 11/5/23. I have filed a stay vacating application. And perhaps if lordship sees the order of the last date, there is an observation to the effect that
there's an IA, separate IA.
an IA for stay vacating that is filed at my instance, the respondent. for.
So is that why it is listed today?
Lordship,
for
yes,
considering the
lordship, for
IA?
Final hearing of the matter. So the last observation was.
Oh, this is for hearing,
Yes,
Yes.
yes.
I see.
Only observation, lordship, is that if it cannot be taken up for final hearing, then the stay vacating application will be taken up.
Where is the last order? In the IA?
No, lordship, common order in the main case. In the main case, last one.
In the main case, last order.
Yes, lordship. The observation is of 19/12/25. It has been continued in the last order. Yes,
19/12/25.
Supposed to submit some written argument.
lordship, I have prepared that.
Bullet points.
I may be hand over. I have a list of dates and a short. Thank you so much.
You have already prepared
Yes, lordship.
and you have submitted it or you have not submitted? Oh, it's there, everything, okay.
So, prepared a short list of dates as well. Perhaps if lordship permits, I can place the list of dates.
So as of now, conducting counsel is on legs
That's
for the
what the
petitioner.
division bench.
Who is the petitioner otherwise?
Lordship, we are an
Public
NGO.
spirited,
We're an NGO.
NGO,
Lord.
NGO. NOC Foundation.
Lord.
Any other matters taken up by this NGO besides this?
Lordship will find in our first paragraph itself. Will. Paragraph 5, your lordship. Already given our particulars, your lordship. The NGO's part.
The individual is working in the field of environment.
Environment. Your Lordship.
Name and style is NOC Found. What does NOC stand for? NOC?
Lordship.
There's some
New opportunity for children. New
new,
opportunities for children.
I see.
If lordship permits, I may hand over the officer dates.
Also, otherwise, Lordship, may I put a matter of pass over time being your Lordship? Or
Oh,
if-
definitely,
if
we'll,
some
we'll,
difficulty on the
we'll
part of your
accommodate,
Lordship,
we'll
there is some
accommodate you.
undertake your
We were just trying to
Lordship.
analyze what the matter is about.
Lord.
And another thing which you perhaps learned counsel should keep in mind is
Lord.
that this is not that regular bench. And we
Lord.
don't know when this composition will be there again. So you don't want to keep things hanging like that, no? This is another aspect which
So Lordship, the
Yes.
bench is available next week, your Lordship.
next week we are not available. I'll be out station, brother may be here, something like that. So now this Central Pollution Control Board, who is there? You are there for the pollution control board. You have filed your affidavit and all that. Okay.
Readings are complete, your Lordship.
Readings are complete. So basically, they are challenging your permission given by you, isn't it?
They're challenging.
Uh-huh. And state has anything to say apart from the pollution control board?
No,
No.
in fact, in this matter, I'm being led by Learned PhD, who is also representing the state pollution board.
I see. He's available today.
Yes. He's on.
He's on legs. So even petitioners council is on legs.
But if
So
I may
we'll
suggest,
we'll
Lordship,
pass it over for the time being.
Lordship on 18th, otherwise, your Lordship.
Huh?
18th, your Lordship.
18.
Lordship.
18 is what? Wednesday. You have a consensus
Lordship.
because both sides, the senior councils are
Lordship.
appearing.
Lordship.
You check your diary and let us know. Perhaps it'll be better to have a date.
Or else, Lordship, with the convenience of all the parties. So we may pass on the convenient date to the learned, bench assistant.
That can be done.
My only prayer would be because my stay vacating is pending. Should we
correct.
just continue that observation regarding in the event that the matter is not taken up finally? At least I have the liberty to press the stay vacating application.
Right.
That
That will be good.
Lordship, there's no difficulty, your Lordship.
Come to a consensus, okay?
Lordship.
Item 6.
Lordship, the interim order needs to be continued, your Lordship, otherwise.
Or should we pass an order just
Lordship,
now?
you can pass the order, your Lordship.
Okay.
You are available, your Lordship.
You'll just write, the learned senior councils for the rival parties are said to be engaged in a different court and are on legs. Full stop. This court earlier had observed that if the writ petition is not finally heard, the interim prayer, the vacation of the application for vacation of the interim order should be taken up. Next para. Considering the above position and the fact that the present bench may not be likely to sit in the coming week, and as agreed to by the parties, the matter be listed on so and so. Stop. Till then, the interim order passed earlier shall continue. Stop. Further, the observation that if the matter is not taken up for final hearing, the application for vacating the interim order should be taken up, stands extended till the next date.
Lordship, may I pray for 25th, Lordship?
No,
So we'll come to a consensus.
already I have written before the court, we are giving a convenient date.
Okay, okay. Lordship.
Give a date.
Lordship.
Inform the court master, we'll put that.
Item 6.
Maybe. But this is against the judgment of conviction, madam. And the petitioner identification was not done, madam.
Actually, this case was prepared by my learned senior friend, colleague. Yeah.
Who? Bhuya.
Give here, but
Bibu.
I will try to assist your lordship.
The point is very simple, my lord. And actually, it's a case of acquittal, my lord. Because a wrong identity person, my lord, was picked up by a nickname Doya, my lord. Even police could not identify his identity, and he was put behind the bar.
Conviction under which section?
Under 302, my lord, directly.
302.
Even the victim was alive for 2.5 months. Somebody in the isolated area at night beat him, my lord. That is the only thing. No weapon, nothing, my lord.
Okay, apart from the state, any other party involved? Just the appellant and the state.
Yes. Informal is a formal party only, my lord. State is there, my lord.
Okay, this is an appeal from jail or it's a
It's a private, my lord.
private appeal?
Yes, but he
Okay.
is in jail, my lord, for last 2.5 years.
Where is your appeal? Otherwise, it's a part of the paper book,
Yes, yes, ma'am.
starting from page
Starting from page 132. ma'am.
132.
Yes. I'll start from the FIR, ma'am.
Yes, just a minute. 132 the appeal. Then
14 witnesses were examined.
Yes.
sentence is for
Sentence is under section 341, my lord, and 302.
life.
For life, my lord.
302.
Yes, my lord. And in what circumstances, whether he was picked up, my lord, I do not know, my lord. And the details of the part of his crime, that is also not established, my lord.
No eyewitness.
No, nothing, my lord. Just by a nickname Doya, my lord, this person is. May I start from the FIR, my lord?
Yes,
Page 4 is the FIR. May I read it? my lord?
page 4.
The incident, may I read it, madam? I have the honor to state at around 9 p.m. on 28/3/2015. That is the date of incident. On 28/3/2015. When my brother Haradhan Asharji was returning from the market, someone assaulted him with behind Detoxera Kalibari and left him there. When I got the information at around 3 a.m., I went there and saw that he was lying in an unconscious state. Then I brought him home and nursed him back to health. Thereafter, I came to know from him, my lord, that Doya Amar, along with two of his associates, confined him, assaulted him, and left him there. I therefore pray for you to take necessary action so and so. Now, this FIR was lost, my lord, after 3 days, my lord, on
Date?
31/3.
31.
Yes, ma'am.
His name is
Died, yes.
Dayamal.
Now, your lordship, and he was arrested, my lord, only on 16 June, my lord.
No, who's the complainant?
Complainant is this Babul Asarji, one brother, my lord, of the elder brother of the that victim, my lord. So this incident happened in an isolated area at night, dark night, and nobody knows who has beaten and nothing. But only name one nickname Doya, my lord. That is the whole thing. Now, your lordship, with your lordship permit, I will
Yes.
proceed further with PW1, your lordship. Page number 8.
The FIR was registered under 341, 325 and
FIR
34.
registered, my lord. Yes, 341, my lord.
Hmm.
325 and 34 IPC.
Hmm.
34 because in the FIR it was stated
Others.
Doyama and two associates.
Two others, two
The
associates.
police could not track anybody. The other three, my lord, some reports are given
Uh,
that they could not be tracked, traced out or absconded. But who are they, my lord, nothing police could find out. And
Then-
actually, my name, my lord, I do not know. I became the fourth one. He stated Doyama and the two associates.
Hmm.
And three of the person, my lord, maybe the real offender, they already absconded. And I am just the fourth one without any cause to pick up, my lord.
How it becomes four? It's becomes
If we
three only.
count, my lord, if we count.
Count
in the
from?
Search sheet, it is shown that there are three main accused in the search sheet.
Charge sheet was filed against 3 persons
Yes, ma'am,
and charge was also framed against 3 persons.
3%.
What happened to the other two? They were also
Other were declared offender, my lord.
proclaimed absconded.
Yes,
So they disappeared.
yes,
No, the FIR says Dayamar
yes.
and
FIR
two
says
officer associates.
two is
That means three of them.
three, but in the search sheet, there are four, ma'am.
Four.
I am the lowest one, man. I do not know, they could not properly conduct the investigation. Who are the real offenders, but subsequently, my lord,
Appellant is not Dayamar.
not Doyama.
Somebody else. Okay.
When, maybe, my lord, when some beating was taking, somebody may have whispered the name. And on presumption, the witnesses are proceeding, my lord,
Hmm.
that he may be the person, my lord. That is the thing.
Okay, page 6 is the charge,
Yes, sir.
framing of charge.
Charge was framed, my lord,
Hmm.
under section 341, 302 and 32. Now, may I read PW1, your lordship?
341 and 302.
Yes,
Only two sections, isn't it?
yes. 341 wrongful restraint.
But where's the recording that
My lord.
the charge, the plea of the appellant, it does not admit to the charge and he claims for trial and all that.
Page 6 is the charge, my lord.
Hmm. Signature is here of the session judge. There's nothing
Yes.
mentioned.
Session judge signature is due.
What does the plea of the appellant before the session judge while framing of the charge?
Plea, my lord, maybe, my lord,
Denying the charge.
denied it, he contested the trial.
It is not here. That's why I'm asking you.
Maybe in the, my lord. Maybe in the record.
But this is the entire form.
Yes,
Signature is already there.
yes, ma'am.
Just see the order sheet of the trial court, 14 February 2019.
The first date of calling for prosecution.
Order sheet 14/2/2019. Anything recorded?
The Doyamar was never found.
Not, never found, my lord, and it's not a,
You are
my,
saying that this person is Doyamar.
they are saying that Daini Singh Pudaite is Doya, my lord.
Okay, it is there
That is,
in the order sheet. I've explained the interpreted the accused to which the accused pleaded not guilty and claimed to be tried. Okay, good.
yes, that on that day he was returning from cultivation and he was in home, my lord. The
Okay.
Doya Daini Singh, his statement is there. He did
All right,
not
we'll
know.
see that.
Yes.
Then next.
Next, your lordship, PW1.
Hmm.
Prosecution witness, phase 8.
How many witnesses in all?
Total, my lord, 8 witnesses, my lord.
And defense?
Sorry, my lord, there are 10 witnesses. And defense DW 1 and 2.
Two defense witnesses.
Yes, my lord.
That's all.
From their village, my lord. They said that we know him by Daini Singh.
Hmm.
And the victim, my lord, he was alive for 2.5 months. But during that time, no dying declaration, nothing was recorded. That is another aspect, my lord. Which goes to the reliability of. And that dying declaration was also not exhibited, my lord.
It was not recorded.
No, not recorded, my lord. Recorded but not exhibited. Recorded after 2.5 months from the date of incident. And that too at his home, my lord. When he was in a fit state of mind.
PW1 is the complainant.
Yes, ma'am. No, my lord, he is one of the witnesses. Complainant is PW3, my.
Okay, anyway, let's go serially. PW1.
Yes. PW1, patient. May I read, my lord?
Yes.
I know the accused person on the dock. His name is Doya Hamar. The incident took place about 3 years ago. We used to work together with Haradan Asarji. Haradan is the victim. On the following morning of the incident, I along with Rajesh Mishra went to the house of Haradan Asarji and called him for our usual daily work. But found him in injured condition. Haradan told us that he had been badly assaulted upon the night before by Doya Amar and 2 of his associates at Detoxera Bazaar, and that they threw him to a ditch, and that he was brought back home by his elder brother Babul Asarji the next morning of the incident. Thereafter, Babul Asarji went to Detoxera outpost, and in the in-charge of Detoxera outpost suggested Haradan Asarji be taken for treatment to Silsor Medical College Hospital. Accordingly, Haradan was taken to Silsor Medical Hospital, Silsor, and thereafter he was taken to GMCH Gauhati for better treatment. And on the advice of the doctor at GMC, they brought Haradan Asarji back home. So he was recovered, then he was brought. He recovered. After a week later, on reaching his home from GMC, Haradan Asarji died. That is the thing.
So PW1 used to work together with the deceased.
With the deceased, madam.
What kind of work? What kind of work?
Well, is a possibly daily work, usual wage labor. But that was a general assertion regarding I know Doya Hamar in the dock for the first time. General assertion on made by PW1 regarding the identification of the accused in the dock.
He referred to him as Doyama.
Yes. But he did not say that Doya Hamar is also dining, and what is his the father name, his identity, address, nothing was said. In cross-examination, loss will find. Cross-examination married. He was not sure, my lord, of who is Doya Hamar. Cross-examination say, I came to know about the incident on the following day of the incident when I, along with Rajesh Mishra, went to the house of Haradan Asarji. Haradan Asarji only named Doya Hamar to be the perpetrator of the assault only. But he did not tell, but he did not tell us regarding Doya Hamar's father and address. I know Doya Hamar from before the incident. There could be some other person by the name of Doya Hamar, but I am not certain. He is not sure, my lord. The person before the dock who is deposing after 4 years. So his statement is not trustworthy. But I am not certain. It is not a fact that present accused Doya Hamar is not involved in the incident. I, along with Rajesh Mishra, went to the house of Haradan Asarji. He was at his residence. He was taken to Haramza Hospital on the same day and thereafter to Silsor Medical Hospital. Haradan died at his residence. So, my lord, may I pause, my lord? From the date of incident to the treatment in hospital, no dying declaration in presence of doctor or magistrate was done at the relevant time. Now, what happened, my lord? Last line. As I am not expert, I do not know the reason, cause of death of Haradan Asarji. I did not personally see or witness the incident. This is important, my lord. My knowledge about the incident is based on what I heard from Haradan. Now, Haradan evidence has not been exhibited also, but only 161 statement recorded. That too after 2.5 months. So basically, my lord, I was behind the bar from that day, my lord, only on presumption that he is Daini Singh is the Doya. And this, my lord, identification of accused person, my lord, on assumption is violates, my lord, Article 21. That is one judgment I brought, my lord.
Violation of?
Identification of an accused person on presumption or assumption without certainty is violates Article 21.
Okay.
I have a valuable right, my lord. If a wrong person has been put behind the bar, I have not responded also. I was picked up from my home, my lord. I cooperated. And police say, my lord.
Charge was framed against the Gauhati.
Yes.
This person.
Yes, sir.
If there is any idea, if there is any alias names, it should be incorporated at the stage of the
Yes.
charge.
At that time, they could have conducted, my lord, TIP, my lord, under section 9. That was also not done, my lord. So that, my lord, it can be given reliability and confirmation of the identity. Now, your lordship, I'll come to that argument on PW2, my lord. Page 9. May I read, my lord?
Yes.
Rajesh Mishra, PW2. He is a hearsay, my lord. I do not know the accused present on the top. This is Haradan Asaji was my friend. We worked together. The incident took place about 3 years ago. One morning, I went to the house of Haradan Asaji and called him out for our daily work. But Haradan Asaji told me that the night before he was badly assaulted by accused Doya Amar and 2 of his associates. Only then I came to know about the incident. So he's a hearsay, my lord. And cross-examination, he said, I went to the Haradan Asaji at around 8 a.m. in the morning. I came to know regarding the incident from him. I did not see or witness the occurrence. He did not see or witness. When I went to the house of Haradan Asaji on the following day of the incident, he was at his residence. So when he was a resident, my lord, the PWT did not lodge the FIR, my lord. On the same day, my lord, he says that Haradan was at residence. He injured condition. But the brother PW3, he did not lodge the FIR in prompt in time, my lord. He lost after 4 days, my lord. After creating a scenario, he lost it, my lord. So, Haradan Asaji did not tell me regarding father's name or address of the culprit. So, father name and address of the culprit or the accused is never known, my lord. Who had assaulted him? He only told me one Doya Hammer. That much, my lord, only one Doya Hammer. And 2 of his associates.
So PW1 and 2 had gone
Yes.
together.
Yeah.
That to the deceased house.
Yes. The both are working together with the deceased.
So they heard it from him only. He said Doyamart, that's all.
Yes. But they do not know the name, address, and the father name of the person.
Then PW3,
PW3 is the informant, my lord, the brother of the victim, my lord.
elder brother.
Elder brother. Babula Sarji. Now here, your lordship, page 10, my lord. How the full name of the accused is given in the deposition, that is very peculiar, my lord. Your lordship will see PW3. I know the accused name Doya Hamar. Then it says alias Daini Singh died. But in cross-exam, he said, I do not know his full name, my lord. How did, my lord, the trial court has, my lord, at that state, added the full name of accused?
Why don't you just read first?
Yes, ma'am. I know the accused, namely Doya Hamar alias Daini Singh Pudai, present on that dock. The incident took place on 28/3/2015. The following day at about 3 AM, one Srimati Korobi Rai, somebody, Korobi Rai, she was not examined also, but telephone, told me over phone that my brother Haradan Asraji was crying behind Kalibari at Titoksara Bazaar. On hearing this, I, along with my brother Amal Asarji, went to the spot and found my brother Haradan Asarji in injured condition, lying by the side of the ditch. Then we brought him back to our house. On being asked, my brother Haradan Asarji told me that accused Doya Amar and two of his associates thrown him to the ditch, as a result of which he became unconscious. After he regained his sense, he cried for help. Then we informed Detoxer Outpost and filed FIR to the insert Detoxer Outpost. Exhibit 1 is the FIR, is my signature. Then you'll also see, after 2.5 months from the date of incident, my brother Haradan Asarji died. This is the thing. At our residence, after having undergone treatment at Silsor Medical College as well as GMC Gauhati, he died due to internal injuries sustained by him because of attack on him by accused Doya Hamar. This person who attacked who, nothing, there is no evidence. Who is the perpetrator of crime, because nothing was seized also, and nobody was present. Now, cross-examination, Lordship will see. There was a delay in lodging the FIR, as I had to attend my injured brother for his treatment at Silsor. But he was available on the next day, my lord. As per PW 1 and 2, he was available, my lord. But they did not lodge the FIR next day, my lord. PW 1 and 2 visited their residence, so he was present on that day. Your brother was also present. I do not know, second line, my lord. I do not know the full name of Doya Hamar, my lord. Kindly see, my lord. As in the deposition, the name of accused is Doya Hamar, alias has been. How it has been added, my lord? It brings a question.
Mr. Counsel, you read, complete reading first, then you submit. You're reading and submitting, so many pauses here and there.
My lord,
That flow is not there.
I
You
read.
complete the sentence, entire thing first, then you submit.
Then I'll continue, my lord.
Yes.
I do not know the cross-examination. I do not know the full name of Doya Hamar. I know the accused Doya Hamar, but I do not know his father's name. My deceased brother also did not mention the name of father of Doya Hamar. I knew Doya Hamar from before the incident. According to my deceased brother, Doya Hamar and his two associates were under the influence of liquor at the time of incident. My brother was not called at the police station to identify the accused person. This line is important. It is not a fact that there could be other person by name Doya Hamar in the same locality. Though the time of the incident around 9 PM at night, it was not completely dark as light from railway platform reached the area of the PO. It is not a fact that present accused Doya Hamar who is present in the court today is not the culprit. So this is the statement of PW.
Okay.
So he do not know, my lord, in cross-examination, he do not know the name of Doya Hamar, full name and his father name and also the address. So here identifications of the subject of the person concerned has to be, my lord, established, my lord, by the prosecution.
Then
Now next PW4, my lord, Abdul Jalil. So he is just a hearsay, my lord. He has not stated any relevant fact, madam. So
Could skip.
skip madam. Next is PW5. Page 12. Bana Bihari Asarji. So he is one of the brother madam, of the deceased. PW5 madam. So his version is also relevant madam. May I read madam? This is Haradan Asarji was my brother. On 28/3/2015, the incident had taken place. After 15 days of the incident, my another brother Babul Asarji brought the victim Haradan Asarji at my house at Tati Rail after being discharged by the authority of GMCA Gauhati. On being asked, my brother Haradan Asarji told me that on 28/3/2015, he was badly assaulted by an accused, lawyer Hamar, along with two others at Detoxera, from where he was shifted to Harangazao PAC. Thereafter, he was referred to SMCA Silsor and then to GMCA Gauhati for treatment. After about 2 months, after about 2 months, he could not recover himself from the injuries sustained by him and later on succumbed to his injury at my residence. The police was informed and the police took the dead body for PM examination. My brother Babul Asarji accompanied the dead body. Now, cross-examination is important. I do not know Doya Hamar. He do not know. I also do not know the present accused, who is present in the dock today. My brother Haradan Asarji told me the name of Doya Hamar at Silsor Medical College Hospital. My brother did not reveal any further details and particulars of Doya Hamar, like his village, etc. I was not present when my brother Haradan Asarji was examined by police and his statement was recorded. As such, I do not know anything regarding the statement of my brother Haradan Asarji. So this is not supporting the prosecution case regarding the identification. Now, your lordship, next is PW6. He is the IO at that time, my lord. Married, my lord.
Yes.
On 15/6/2015, I was attacked at Tatigora. I was attached at Tatigora PS as ASI of police. On that day, OC Katigora PS so and so received information from Sri Babul Asarji to the effect that on 29/3/2015, his brother Haradan Asarji was assaulted by some miscreants. Man. That was the actual at Detoxera. After getting information, his brother Haradan Asarji was admitted at Silsor Medical College Hospital. The doctor whereof referred Haradan Asarji to Gauhati Medical College and Hospital for better treatment. After recovery of his injury, he stayed at his brother's house at Kati Rai under Katigora PS, where he continued his treatment. However, Haradan Asarji succumbed to his injury at his brother's house at Kati Rai under Katigora. The OC made a ZD entry 474 dated 15/6 and instructed me to conduct an inquest on the body of deceased Haradan.
When did he die?
He died, my lord, on
1510 or 15/6?
16/6. 16/6/2015.
16/6.
Yes.
Okay.
Now, your lordship will see the cross-examination, page 14. I got the information and knowledge regarding the assault upon Haradan Asarji and also regarding his treatment at Silsor Medical College, Silsor, at GMCH Gauhati, and also his subsequent treatment at his brother residence at Patirai from his Babul Asarji. So he knows from the beginning that he was under treatment, but no, his statement was recorded of the disease when he was alive, my lord. When he was injured and alive at the time of incident.
What was the investigation done by him? PW6?
My lord.
What kind of investigation was done by him?
He, on the basis of the witnesses' statement, he only directly arrested the accused, my lord. That is the thing, my lord.
No, see, he say that he did inquest
Yes.
over the body of the deceased.
I conducted the inquest over the dead body of Haradan Asarji in presence of executive magistrate and other witnesses. That much he has done, my lord. After conducting inquest, I submitted supplementary case diary to OC Katigora.
So his information was dated 15/6/2015 only.
Yes, ma'am.
FIR was lodged on 31/3.
31 months.
Who conducted the investigation after the FIR was lodged?
This PW, my lord, may I see, my lord?
The first IO.
First IO, my lord.
PW6 is the second IO.
Yes. PW8. sir. Yes, yes, PW8.
PW8.
Yes, I'll come. PW8 Gunojit Pathapu.
So PW6 is just inquest
Inquest and
in arrest also.
no, only inquest.
Only inquest. Nothing much to say. He has not said anything about that name, Doya Mar,
Nothing, ma'am.
or the present name of the appellant, except for saying miscreants. Okay.
Then PW, may I read PW7 my lord, serially?
Yes.
PW7 is the, my lord, this doctor, my lord, who conducted a postmortem. But the treating doctor was not examined. Treating doctor, and he was not a witness. Page 15. The deposition of PW7, namely Dr. Netramani Kakoti. On 16/6/2015, I was posted as demonstrator in Department of Forensic Medicine, Silsor Medical College. On that day, police brought one dead body of Haradan Asarji, ages 45, in connection with Katigora PS GD entry number so-and-so, dated 15/6 for PM examination. Accordingly, I conducted PM examination on the body of the deceased Haradan Asarji and found the following observation. External examination, one male body of chin so-and-so, brown complexion, wrist case prominent, bony marking is prominent, eyes were partly open, mouth so-and-so, rigor mortis is present all over the body, and as so-and-so, healthy. These are it. Injuries nil, my lord. Mark of ligature on the neck is nil. Cranium and spinal canal, scalp and skull is also healthy, my lord. Only page 16, vertebra contused at level C5 to C7, transverse fracture present, body of cervical 6 vertebra. And other things are okay, my lord. Only in my opinion, that was due to shock resulting from injury present on the cervical vertebra as described, which were antemortem and caused by blunt force impact. Now, cross-examination is important, my lord. The injury was an old injury, and apart from the injury, there was no other injury. The injury could be caused if a person falls from the height of 10 feet over a hard surface. Since it is an old injury, external injuries could not be found. So it was an old injury, and that can be caused if a person falls from height.
Correct. So incident happened on 28th March.
Yes.
He died on 16 June.
Yes.
Almost 3 months.
3 months.
So injury would have healed. Only thing is that vertebra confused and spinal cord confused.
Yes. And that is in cross-examination, it was stated that injury could be caused if a person falls from a height of 10 feet over a hard surface.
He was found on a drain, isn't it?
Drain.
Somebody threw him on the drain.
Now,
Hmm.
PW7, there is further cross-examination, so page 17. And this cross-examination was recorded, my lord. After
Who's PW7?
that doctor, my lord.
Okay,
Autopsy.
17 is a continuation.
Yes, ma'am.
I see.
After 3 months. My lord.
The doctor,
Yes,
again,
after 3 months, my lord.
3 months.
Yes, and the date is 26/6/23, madam. And earlier one was 10/3/22. So she was examined and they said that the injury found in the body of deceased as mentioning serial number 1, vertebral complex level number C5 to C10 was fracture present, body of cervical, so and so. And there is fracture of the cervical in the 6th vertebra. So that fracture person she has explained. Now, who has caused the injury and who was the perpetrator of the crime? There is no evidence of the prosecution.
He suffered a fatal injury in the cervical
Fatal.
region.
Because
Responsible for the death.
yes, as per the injury, there were my lord, three person, lawyer and who. The other who are this, my lord, police could not trace out. And how he is connected with the appellant, that is also not known. Now, next is PW8, my lord, page 18. This is the, my lord, IO, my lord. May I read, my lord? Gunojit Pathak.
Hmm.
On 31/3/2015, I was posted at Itoksara OP as IC. On that day, I received an information from Babul Assaji that his brother, namely Haradan Assaji, was seriously assaulted by one Daya of Nasangal village, along with 2 other persons. As a result, his brother became unconscious and thrown into roadside. Then I made a GD entry by Itoksara OP so-and-so dated 31/3/2015. Then I informed the OC Harangzao PS. At that time, Babul Assaji also lodged on written FIR, which was forwarded to OC Harangzao PS and registered a Harangzao PS case number so-and-so. OC endorsed me to investigate. This is the IO. Then I examined the complainant and recorded his statement. I visited the PO and drawn a sketch map of the PO. Exhibit so is the sketch map wherein exhibit so-and-so is my signature. I also examined the witnesses and recorded their statement. In the meantime, the injured person, namely Haradan Assaji, was shifted to Silsor Medical Hospital for treatment. I visited Silsor Medical College for recording the statement, but I could not record his statement as he was not in a position to depose. So this is also brings something uncertainty in the evidence of PW1 and 3 that he stated the name of Doya Ahmad, because PW8 says that he was not in a position to depose also, my lord. In such a condition, my lord, if he was shifted to Silsor Medical, my lord, then the earlier statement of this is not trustworthy, my lord.
When was he taken to hospital? The incident happened on
Incident happened at
28/3.
28/3, my lord.
Then hospital?
Hospital, my lord, is not clearly stated, my lord. In the evidence, it is not.
SMC,
First, they have taken to Silsor Medical,
then GMCH.
then for further treatment to GMC. Then
So,
from GMC
Back home.
to back home
Home of his brother.
of his brother.
He died.
Yes,
date of SMC and GMCH is not there?
not there, my lord, because treating doctor was also not examined, my lord. That is the thing, my lord.
No, from the evidence is not available.
Not available.
Dates are not available.
So far, my knowledge, my lord, I have not found, my lord, but.
No, so far as the incident was concerned, he was able to narrate next day.
Next day.
So and so had done, so and so had done. to his just two friends
Yes,
with whom he used to work, daily labor. He told his brother also. But so far as the IO is concerned,
yes.
FIR was lodged
On
only
31.
on 31/3.
Yes,
That means after 3 days.
yes.
And when he tried to investigate, he was not able to record the statement because he
That
was
is
not in a
absolutely
position to depose. Then I also gave,
I also given a requisition to Superintendent Silsor Medical College for medical examination report. After release from Silsor, the victim was kept in his original house at Katigora, where I visited and recorded his statement.
no, he recorded.
Recorded after 2.5 months.
Hmm.
161 was recorded.
Hmm.
I have also collected the medical report from Silsor. So and so is the medical report collected by me from the Silsor. After receipt of the medical report, I prayed to the court to add section 307 IPC. In the meantime, I arrested the accused, namely Daini Singh Udaiti. So he was arrested on 16/6. On the basis of the statement of the witness. Kindly note, my lord, this is the evidence. This is the, my lord, investigation. In the meantime, I arrested the accused, namely Daini Singh Udaiti. On the basis of statement of the witness, I also searched to arrest another 3 accused. Namely, this is the name, Pogin Hamar, Gumping Hulong, and Rustam Murti. But they are already absconded. The arrested accused, namely, was forwarded to the court. So there were other 3, my lord, and I was the 4th one. During the course of investigation, it was reported by the OC Katigora PS that the victim Haradan Assaji expired due to previous injury sustained by his person on 15/6/2015. They sent the dead body to Silsor for PM, which I have collected from the OC Katigora PS along with SCD. After investigation to the case, it is found well-established evidence against the present accused, Daini Singh Uday, and other 2 accused. The accused, namely so-and-so had absconded, and there was no immediate chance of arrest. So I submitted searching showing them as absconded in this case. Now cross-examination. FIR was registered on 1/4/2015. The date of incident was 28/3/2015. This is the period, madam. The distance between place of occurrence and the OP is not far. As also the place of residence of the victim is also not far from the OP. Not far, madam. I did not seize any weapon or instrument of assault from the PO. I did not seize anything from the arrested accused. It is not a fact the witness have stated that one, Doyar Hamar, and 2 others were involved in the incident. It is also not a fact that victim and the witness did not state the name of Doyar Hamar, his father's name, and his address. The identification of accused was not conducted. It is stated that the identification of accused was not conducted. So that must, these are the statement. So on the basis of, my lord, the statement of witnesses only, he was arrested. Now his name, identification, father name, address, nothing was been, my lord, came out in prosecution case, my lord.
Then next.
Next is, my lord, PW 9, page 21. Dr. Sudipan.
So you must be informing on which date he was there in the hospital.
On 31/3, he said, my lord, on 31/3, I was posted on Silsor Medical College as Registrar, Department of Orthopedic. On that day, I prepared a medical report on the basis of hospital record on police requisition of Haradan Assaji. which is already been exhibited at PWSP 14. There is only cervical spine injury on the patient and no other injuries. That must only.
Where is the medical report?
Medical exhibit
P14.
P14, my lord.
Let's have a look at that.
Page 123 of paper 2. Page 123.
Anything written here? Date of admission, date of discharge, no
Date
that?
of examination is given, my lord. 31/3/2015. And nothing else, my lord. Discharge.
31/3, he himself said that he prepared the report on that day.
Yes,
But regarding the admission and discharge, anything?
nothing. That is no other doctor or treating doctor examined, my lord.
Was he admitted at all? Or he was just examined and discharged?
Maybe, my lord. From the record, I could not find paper 2.
No, from the evidence which you have read so far.
He was referred to, they say, since Gauhati Medical.
No, before that, he was taken to SMCH.
Yes, ma'am.
Then he was taken back again to his home.
No, from Silsor, he was referred to GMCA for further treatment.
No, somewhere I've seen that he's gone back home. And from there again he went to GMCH.
Maybe PW8, my lord. IO, my lord.
Ayo.
IO statement maybe, my lord. IO, my lord, page 18, my lord. Last portion he says, no.
See, after release from the Silchar Medical College
Yes.
and hospital, victim was kept in his original house at Katigora.
Oh, that IO says, man.
IO says.
IO says.
Did you say anything about forwarding of the victim to GMC?
Then how did he land up in GMCH after that?
Might not perhaps it might happen that might not be after releasing from the SMCS, he went to home, then he was forwarded to GMCS. That might happen. Or might not, when the IO went to the SMCS, might not, after that, he may be forwarded to GMCS, but the IO didn't stated anything regarding that.
So that is the impression we're getting. First SMCH, then he goes back home, then from there GMCH.
Yes.
Then from there again home.
Again.
So PW9,
PW9.
nothing much. He's prepared a report.
Yes.
What kind of report is this? Allegedly HO physical assault. Then these are all medical terms, isn't it?
Medical term.
We'll have to decipher this. What is this SLRT bracket R? R must be right. L must be left. Then LL means what?
Page 120.
Page 123.
Page
123, description of injury.
cervical spine injury.
Spine. Spine.
He was having injury on the cervical spine.
Cervical spine.
Due to some kind of, I think, some kind of paralytic involvement is in the case. With an incontinence.
Where is that?
That's what is not.
Cervical spine. It says SLRT. Cervical spells with C, isn't it? Not S. This says SLRT. Bracket R. Okay.
Yes, then may I take your lordship to the sketch map, your lordship may kindly see, phase 121.
Sketch map.
Yes. The place of occurrence on the Kalibari Road. Phase 120.
Before that, what is this page 22?
Huh?
Who's PW page 22?
Phase 22.
Yes, who is he?
Phase 22, yes. Is an enquiry officer.
But what is the number? PW what?
EO, it's written.
Page 22, he is the person who was entrusted with the
Regarding
PA regarding other.
absconding accused
Yes.
was the.
Yes, other accused.
executed the proclamation.
Yes, to execute them. PW is page 22 and 23 same.
So he also made a deposition before the court?
Regarding, because there are other accused. persons
Three
who turned up.
accused, other three accused.
Other three accused.
Who were absconding. As
So
per the-
that's right. What is he named as? PW what? Just PW.
Just PW, my lord.
EO.
No number.
No number, it's page 22, 23 and 24, three, my lord. There are three persons.
Actually, on the basis of his deposition and probably the proclamation report was accepted.
Yes.
Two people were declared as proclaim absconding.
Three, my lord.
Three were declared as
Yes.
proclaim absconding.
And as per FIR also three, my lord.
22, 23 and
24.
24, please. Okay. That was on 5th July 2018.
So it may be, my lord, possibly like they have committed the real scene, in the real scene, they have committed something and they have run away, fled away. Somebody might have whispered Doya in the ear and this may be the situation, but
It's very easy to blame a deceased person
Just-
or an absconder.
one side of you, my lord.
So
So
that's all.
now.
Insofar as PWs are concerned.
Yes.
Hmm. So how do you sum up the prosecution evidence?
My lord,
Now you can sum up.
prosecution.
Every line by line you are summing up. Now you can sum up together.
Now, my lord, 161 statement of the accused is also there, my lord.
Hmm.
He says, my lord, on that day, on 15/6, he was examined by police, my lord. I only have a certified copy, my lord,
Who?
of the accused. He said, my lord, on that day, he was 28/3, he has returned from his paddy land after cultivation and he was in home. That was the first statement by police.
Statement by the accused
Yes,
before the police.
yes. And I am known as Daini Singh Putaiti. So that is the statement.
Must be available here also.
Yes, my lord.
From here only you
I
obtain.
have a certified copy. In the case that.
Was any question on these lines put in the 313
Yes, my lord.
regarding his identity?
That was, I was supposed to put it out.
Yes, my lord. I'll come to that, my lord.
313.
Page 28 is that she wants.
Oh, it's written in vernacular.
My lord may see page 39.
No, that I'll come, my lord. It starts from page 28, my lord. 31.
Therefore read this, brother. It's vernacular. Can't read it. Which page?
Page 28, my lord.
20 starts.
Yes.
That question was my landed, honorable, without it, but that is, that answer is in place.
39.
39.
This 313.
31, my lord, 39 is, my lord, that is after about, recorded after about 3 months. 5 months, my lord.
Hmm?
This 313, my lord. Initially, it was closed on 9/2/2023, as per page 38. And page 39, my lord, again, he was, for further 3-1 statement was taken up after 4 months, my lord. I do not know, my lord, how, why it is taken, my lord. It is not a incrementing questions were not put, my lord.
Name was creating some doubt, that's why.
Yes. Doubt, my lord, this is, so far, my lord, your lordship will see page 39. That is, do you have any other nickname? Kindly see, well, these are not the incriminating materials connected to the incident, my lord. He says, no, I do not have any other name. So that is the end of the matter. Then again, my lord,
But he again goes on to say, he is also known as Daya, the market.
that is again put to him, my lord. When the prosecution could not establish their own case, my lord, how can they take the, my lord, the 313 statements to be the, my lord, sufficient evidence? That is after 4 months. And these are my submission, my lord. I have a judgment also. If it is not a incriminating questions, that cannot be expected to put to a accused, my lord. So yes, discharge is burden in question 1.1, page 39. Do you have any other nickname? No, I do not have any other name. In which committee? I belong to Mar committee. But again, my lord, it is putting, my lord. So it does not, my lord, prove the prosecution case, my lord. And page 41 also, my lord. He has stated, my lord, that page 41, I am innocent. I have not committed murder of Haradhan Aswati. Page 41,
Come back.
my lord.
Say that he at least belongs to Mar community.
Mar committee.
Then he also say that he also knows Daya. But he also held first question asking if he does not have sleep.
Yes, that is a thing, my lord.
Whether they will indicate that our secret
Yes.
and they are not secret.
That PIP has.
That is the question.
That PIP is not, that's not.
I'm not sure what the evidence.
That is the thing. On 313, my lord, this question, my lord, page 39, my lord.
39 is 313, is it?
Yes, page 39 on that question, my lord, I am relying on this judgment. On the question that when the accused has to be invited the attention to the evidence and the circumstances appearing against him, my lord. That only has to be put to him, my lord. Now, if these circumstances that PW1 stated that you are known as Doya Hamar and he knows you, these circumstances your lordship will see from the initial 313 never put up. From page 28 onwards of the paper book, it was never put up to invite my attention and obtain a reasonable answer. It was never put up, man. So page 28, question number 1 also, PW1, that he has stated as Doya Amar is dining today. It is that circumstance and evidence was never put up to the accused, my lord. So therefore, I have said, my lord, this question was never there. So therefore, after 4 months, my lord, when this question was put up, that page 39, question number 1.3, do you have any other person in your village by name Daini Singh who died? This is not, my lord, that incriminating circumstances. that they are putting it from the mouth of the witnesses, prosecution. This is not the, my lord. So in that context, this husband says it's just to fill up the lacuna
Are you saying that only incriminating circumstances have to be put to the accused?
so that reasonable answers can be provided.
Not really. I think that incriminating circumstances have to be put in,
Yes,
but not only incriminating substance.
not
The
only,
person can be examined generally also.
generally also,
Generally also.
generally also.
Is that the position, isn't that?
Generally also, but on the basis of this, my lord, the prosecution cannot stands proof of their case, my lord. Because if this question is not put up, it would have not strike to the mind of the learned session, because it was put up after 4 months. Do you have any other person in your village name? So in the context of PW1 and PW3 stating that he has stated that Daini Singh is Daya Namar, that was never put up, my lord. And there is no evidence or in the question put regarding reference to PW1 and PW3 stating the name, my lord. That context, your lordship will see paragraph 30, 31 and onwards, my lord, of my judgment, referred judgment. Paragraph 30, 31 and 41, but that is relevant. Thirty, 31, 32 and 41.
41 is summarized.
Summarize, man. That's why. 41 says, my lord, his answers to the question put to him cannot be used to fill up the gaps left by the prosecuting witness in their deposition. That is, my lord, 41. It will be from beginning. Yes. 8th line, my lord. Starts from however. However, his statement cannot be made a basis for his conviction. His answers to the question put to him under 300 cannot be used to fill up the gaps left by the prosecution witness in their deposition.
And also the inculpatory part
Yes.
of his statement cannot be made the sole basis of a
All
conviction.
basis of. That is the thing. And he was led by a legal aid counsel at that time.
Any other citation?
Yes, ma'am. And one more thing, my lord, regarding 313, that subsequent deposition, my lord, statement. On that day, I obtained a certified copy from the record, and I found that on that day, the legal aid counsel was out of station when this statement was put, my lord. I have a copy, my lord.
On which day?
On the date of,
313.
yes, ma'am. Subsequent one, page 39. The conducting counsel was absent, despite that, my lord, was put up, and the veracity is not known to the accused also. 21st July, my lord, this petition, my lord. So this cannot be the,
When he was sent up for trial in the charge sheet, he was sent up as this name.
his name. Daya.
Where's the charge sheet?
Charge sheet. What should we find? Page 125, madam. Page 126, my lord. Dini Singh alias Daya. But there was no evidence, my lord, regarding the identity of Dini Singh as Daya. That I also admitted, my lord. It was only on basis of this statement of witness PW 1 and 3 only. And in the search sheet, there are, my lord, serial number 1, 2, and 3 are the absconder accused. And my name is below in 4 ones.
Found that investigation accused Daya Singh Udaiti alias Daya.
Yes, yes. So in what manner, my lord, the police has investigated and found that he was, because there was nothing PIP, nothing sort of evidence to prima facie send for trial, my lord. Because the witnesses are saying, I do not know his father name, my lord. I do not know the name and address. Kindly note, your lordship. And how they are sent for trial, my lord, by the IO, the performatory, my lord. And this has not come, in evidence, my proposals. How this person was sent for trial as Aya.
Can you just give me that record, please?
I am one judgment, my lord, on the identification of accused. How actual name is ascertained, my lord. Paragraph 17, 18. Paragraph 17, 18, 19, 20, 21, my lord. Paragraph 17, 18, then 19, 20, and 21. Identification for the first time in court is inherently a weak evidence, my lord. Here I'm relying on paragraph, my lord, 17, 18, 19, 20, and 20. That's just been hamstring.
17 to 21.
17 to 21, my lord.
What is the ratio laid down here?
Here, my lord, this the identification for the first time in court is inherently a weak evidence, my lord. When prior case identification or identity of person is not ascertained. And when he has been identified for the first time in court, my lord. Because their veracity of their statement has to be tested, my lord. When they appear and depose for the first time in court regarding the identification accused, their veracity has to be tested from the prior, my lord, prior statement, which they have, which from the police investigation, or that was not tested, my lord.
Apart from the nickname,
Yes.
what is the other identification of this Daya?
Nothing, my lord. That is a thing, apart from
From
the,
what about his family,
so far PW1,
parental,
family, my lord,
place of residence, where?
PW1 and 3 says that I do not know the name of his father, his address. That is the thing. And the most important is that they have heard the word Doya Hamar from the deceased man. And
Okay,
what
then what is the basis of conviction?
basis of conviction, my lord? Your lordship.
Finding of the trial court?
69, your lordship. Judgment, my lord. Page 69, 27.51, my lord. That was on a wrong proposition, my lord.
It's 27.1.
Yes. 27.1 onwards.
No, any discussion in the accused judgment regarding his nickname?
Yes. That is your lordship. 27.7, my lord, page 73,
There's a conclusion.
conclusion,
Before conclusion, that analysis
analysis.
is not there.
Yeah, it's 27.3.
27 point,
Small Roman 1. Injured, subsequently deceased.
Yes.
That they have been beaten by Daya and
yes,
where is this statement? This is a 161 statement
160,
or 164. That cannot be relied on.
that cannot be 161 by two. how 302 is affected, my lord, and the role played by the accused appellant is also not established, my lord. Make that-
27.7. Ultimately, the conclusion was found regarding the commission of offense. With regard to Dynasty Kudait alias Daya.
Alias Daya.
However, in
how
the
they-
first format, this Daya is not there.
How they have, my lord, linked me to the crime, my lord. That he is the dynasty in the Daya, my lord. And he is the perpetrator of crime and he has inflicted the blow under section 302. That is not there, my lord. It's not also a case of 302 also, my lord. Because it was not a imminent death, my lord. He died after treatment, 2.5 months, he was alive, my lord. And all injury he has died. That is not. So here they have to prosecution has to prove each and every aspect of section 300 IPC. Culpable homicide is murder. And it is none other than the appellant has inflicted the injury. That things are not there, my lord. So 302 is, my lord, has to go, my lord.
Yes, that's it. Anything else?
Anything, my lord, and your lordship will, I have another judgment.
Another judgment on what?
On
Oh.
300, man, culpable homicide. In place.
The SMCH doctor who was deposed as DW 8 or something.
8,
He
9.
he stated that the injury is sufficient, cause death.
Page 21. Jury. No, page 21, my lord, the PW9, Dr. Sudipan De. She says there is only cervical spine injury and no other injury. Because he was cured and when was sent to home, my lord.
This DW1 and DW2, what did they say?
Yes. W1, your lordship, page 25.
How does it help you?
No, they say, my lord, that in their cross-examination, I cannot say whether public villagers call Dainishing Kudai as Daya also or not. One day I heard that police arrested Dainishing Kudai and took him as Harang. It is not a fact that name or accused is Doya and alias Dainishing. So how the investigation process to find out, my lord, that Dainishing is Daya, my lord, that is nowhere in the evidence, my lord. It all started, my lord, after sending him for trial. So,
DW1 is an acquaintance,
yes,
a known person to the accused person.
yes. That section 9, your lordship, evidence says it has to establish the identity of a person is a relevant factor. Section 9 of evidence. That has to be, prosecution has to first establish that.
Where is that examination of the PW9?
PW9, my lord.
Some report was there.
Page 21, my lord.
21.
Yes.
Exhibit P
Page 123, my lord.
14. We had read somewhere now that the injury is sufficient to cause death. Where is that?
She only prepared a medical report. She's not a teaching doctor, my lord. She said, I only prepared a medical report on the basis of hospital record.
The other doctor?
Teaching doctor not examined.
No, somewhere we have seen that injury was enough to cause death.
It's taken. Any statement like that? It's taken. Seven.
Page 15.
Oh, no, it's mistaken.
That is re-cross examination.
Oh, yeah. Okay.
After,
Oh, yes.
Cross examination,
after the,
Okay.
recross.
yes.
Mhm.
Because the earlier cross examination, your lordship, she says, injury could be caused, page 16, my lord. If a person falls from height of so and so,
Mm.
since it is an all injury, external injuries could not be found. Since it is an all injury, external injuries could not be found. That was page 116. Thereafter, my lord, after that, after 4 months, 3 months, this was reviewed.
After 3 months, she was re-examined.
Re-examined. The original one of which was recorded in that time was that since these are all internal, external injuries could not be found.
Okay, you're referring to 2022 9 SSC.
Yes, my lord.
What is the relevant para?
Paragraph number 11, 17. I will read, my lord.
Mm.
Para 11, may I read? We are thus satisfied that the occurrence in a manner as set up by the prosecution has been duly established. That this is died due to injury caused by accused so and so using a stick and a brick, where the injuries caused by PW 1, 2, and 4 are on account of assault by accused 3 by using stick. The only question which requires consideration whether it is a culpable homicide amounting to murder, punishable under section 302 IPC, as has been held by court below, or it was a culpable homicide not amounting to murder, punishable under section 304 IPC, as submitted by the counsel for the opinion. But here, my lord, who is the perpetrator of crime, who has given that fatal blow? Nothing has been came up in prosecution evidence. That is the thing, my lord. Because case map say it was in a public road. And 3 persons already absconded. Therefore, also no, nothing has been brought up in investigation. That is the thing. Now, the lordship. So 302 for my lord, implication of 302, there has to be some sort of role played by me, my lord, or to connect to the scene of crime, my lord. That I was present at that moment and I have given that fatal blow which caused injury or with the intention to cause. So these things are not there, my lord. And so, my lord, last paragraph of that page judgment, my lord, page 779 of that referred judgment, my lord.
No, what about the connectivity between 777 and 778?
778, my.
Yes, is there any continuity?
Yes, yes, continuity is yes, my lord.
Where, from where?
Page 776. It starts from page 776, section 300.
Okay, some 776 to 778.
Yes,
In between, what is there? This is some,
this is the exception when culpable homicide is murder and when it is not murder.
no, how is this, how it has come in between?
My lord,
If you come to page 776.
776, yes.
Hmm.
Section 299, ma'am. Is refers to 77 section 29, culpable homicide. We were,
Correct. From where has it has been abstracted? There's no indication to that effect.
is from section 299 IPC, my lord.
No, that I know.
Yes.
Para 17. Para 17 then.
Para 17 of.
Where does para 18 starts?
It says
Distinctive features, para 17.
17, one paragraph is there.
Yes, ma'am.
776, one small paragraph is there.
Yes,
Continued by section 299.
section 290.
But paragraph number 17 does not say so. That we are abstracting section 299. Anyway, apparently this paragraph continues
Yes,
at page 778.
778.
Courts in this country.
779, I want to read, my lord.
Yeah.
Para, internal para 13, 779.
Okay, okay. It comes continuously. Correct.
It extends from 772, 777.
Yes,
What is the attention of the courts in this country? 4 to 778. This is a kind of footnote actually. This has come like a main page, but it's footnote.
footnote, madam. Just come as a footnote. And main thing, your lordship, page 779, Mayor, that is the consideration to be given while applying section 302, madam. May I read that, madam?
Paragraph 29.
Yes, ma'am. Page 779.
29 of
Page 779.
Pulicherla Nagaraju.
Yes, yes.
Hmm.
That says, my lord, therefore, the court should proceed to decide the pivotal question of intention with care and caution, as that will decide whether the case falls under section 302 or 304 part 1 or 304 part 2. Many petty or insignificant matters, plucking of a fruit, straying of cattle, quarrel of children, utterance of a rude word, or even an objectionable glance may lead to altercations and group classes committing in death. Usual motive like revenge, speed, greed, jealousy, or suspicion may be totally absent in such cases. There may be no intention, there may be no premeditation. In fact, there may not even be criminality. At the other end of the spectrum, there may be cases of murder where the accused attempt to avoid the penalty for murder by attempting to put forward a case that there was no intention to cause death. It is for the court to ensure that cases of murder punishable under section 302 are not converted into offense punishable under section 304 part, or cases of culpable homicide not amounting to murder are treated as murder punishable under section 302. The intention to cause death can be gathered generally from a combination of few or several of the following among other circumstances. Nature of the weapon used. whether the weapon was carried by the accused or was picked up from the spot, whether a blow is aimed at a vital part of the body, the amount of force employed is in causing injury, whether the act was in the course of sudden quarrel or sudden fight or free for all fight, whether the incident occurs by chance or whether there were any premeditation, whether there was any prior enmity or whether the deceased was a stranger, whether there was any grave and sudden provocation, and if so, the cause for such provocation, whether it was in the heat of passion, whether the person inflicting the injury has taken undue advantage or has acted in a cruel and unusual manner, whether the accused dealt a single blow or several blows. The above list of circumstances is of course not exhaustive, and there may be several other special circumstances with reference to individual cases which may throw light on the question of intention. For the safe purpose, we examine the evidence record and invested. So,
main thing is the intention.
intention.
If there is intention with all these factors, it's 302. If there is no intention,
Yes,
person dies,
yes. Intention and
may come under the,
the amount of blow he has given and the weapon used, these things are not there in the prosecution.
how he was thrashed, who thrashed him first, who thrashed him last, nothing was there. Only he was picked up from that drain by his brother, he came back and he said that they had bashed him up, that's all.
He only said that Doya.
Mr. X and two other persons.
Yes. After that, he did not even recorded his statement under 161. His statement of dying declaration also was not exhibited, Lordship. That is also one of my submissions. So his statement of dying declaration was not exhibited. So it has no evidentiary value. When a person who himself is stating that Doya Hamar has given a blow after 2.5 months and his statement itself is not exhibited. So that is also one of the circumstances that prosecution failed to prove. Because if it's a dying declaration, they have to prove, my lord. Once statement was recorded, my lord, at the time of his alive, my lord. It was not in the expectation of death, my lord. That was the thing, my lord. If it is in the imminent expectation of death, that he is going to die now, and he has named Doya Hamar. And this is the, so, but he was alive for 2.5 months. During that time, police prosecution side did not even try to identify that Doya Hamar, and this is the person before, is this the person who has given you the blow? This was never done by police, my lord. And this deceased person, for 2.5 months, he was alive, my lord. After only 2.5 months before at his home only, my lord, his statement was recorded as 161, my lord. Kindly see, my lord. Was it going to give any evidentiary value, my lord? And on that, my lord, lordship, if an innocent person is behind the bar, my lord, and on the basis of my lord, uncorroborated evidence, if he is punished, my lord, that will be, my lord, great injustice. Because 2.5 months, why, my lord, he was silent, my lord? He was in a home, my lord, after treatment. His statement was never put to or never brought in the court, my lord. That is the thing, my lord. And Supreme Court says, my lord, this recording of statement by police, my lord, as dying is discarded, my lord. One judgment is there, my lord. That judgment I will learn on dying declaration. That is, my lord, state okay, I will come to paragraph 29, my lord. Para 29. I read para 29, my lord.
A
A dying declaration made to a police officer is admissible in evidence. However, the practice of dying declaration being recorded by investigating officer has been discouraged. And this court has urged the investigating officer availing the services of magistrate for recording dying declaration, if it was possible to do so. And the only exception is when the deceased was in such a precarious condition that there was no other alternative left, then only, my lord, except the statement being recorded by the investigating officer or the police officer later on relied on as a dying declaration. This court observed investigating officer are naturally interested in the success of the investigation, and the practice of the investigating officer himself recording a dying declaration during the course of an investigation ought not to be encouraged. The dying declaration recorded by investigating officer in the presence of the doctor and some of the friends and relations of the deceased was excluded from consideration as failure to requisition the services of a magistrate for recording dying declaration was not explained. In the lip saying so and so, this court has permitted dying declaration recorded by IO being admitted in evidence and considered on proof that better and more reliable methods of recording dying declaration of injured person were not feasible for want of time or facility available. It was held that dying declaration in a murder case, though could not be rejected on the ground that it was recorded by police officer as the deceased was in a critical condition and no other person could be available in the village to record the dying declaration. Yet the dying declaration was left out of consideration as his contest statement, which was bit doubtful. Now, other thing, you have paragraph 30. So the acquittal was upheld in this case.
I don't get if the condition of the victim is found to be precarious.
Yes.
Can record it, and if he survives or he
Yes.
lives for some time, again it can be ordered.
Yes.
Magistrate.
There's a long gap, my lord, from the date of incident to the date of his death. No, my lord, effort has been made to record his dying declaration, record his statement. My lord. And that you'll also will find in the judgment, his statement was not exhibited. My lord. So when his statement has not got any evidentiary value, the other witnesses saying that this is told us that Doya Hamar has not any evidentiary value. My lord. More particularly when they do not know the name of their father, the name, address, anything. So basically, my lord, my respectful submission, my lord, it's not a case for which the appellant should be punished under section 302.
Tell us one thing, is there any scope for the appellate court to remand the matter back to find out the identity of the person?
In that case, my lord,
Can the appellate court do that?
certain circumstances.
If not, or at what stage can it be done? Just think about it. We'll come back at 2. Surya has come back. You have to come back.
Your lordship may I draw one point.
You have completed.
1 point.
More or less,
regarding
you've completed.
dying declaration, page 68. That dying declaration was not exhibited. It was in the judgment, page 68. Paragraph 27, my lord. That's to show that it does not inspire confidence on the statement of dying witness. There are 27, madam. May I read this one, madam?
Yes.
Statement of the deceased was recorded by IO PWA. PWA in his testimony deposed that he visited the PO, drawn a sketch map of the PO. He also examined the witnesses and recorded their statement. Thereafter, the injured was shifted to medical hospital for treatment. IOPWA recorded a statement of deceased on 4/6/2015. His statement was recorded. In his statement, the injured stated that on 28/3/2015, at around 9 p.m., while he was going to his home, Daya with others attacked him with the intention to kill him. As a result, the injured became unconscious. The accused left the place. When the injured regained consciousness, he made hue and cry. Then the nearby people rescued him. Then his brother took him to Haranga Hospital. Thereafter, he was shifted to Silsar Medical College and Hospital. It is pertinent to mention here that prosecution did not exhibit the statement of the deceased recorded by PWA under section 161 CRPC, though the statement is available in the record. However, the statement of deceased recorded by PWA is not disputed by defense. Here I pause, my lord. This statement, how can the defense, my lord, dispute? It was only a 161 statement, my lord, made before the police, my lord. At that time, he was alive, my lord. So 161 statement cannot be disputed by the my lord accused. So this was, my lord, statement recorded on 4/6/2015. And he died on 16/6/2015. And his statement was recorded at his home, my lord. So there are certain principles of dying declaration where, my lord, the statement cannot be taken into consideration if it is in the vicinity of the neighbors, family members' presence. It has to be, my lord, prompt in time, my lord. That means when he has received the injury, it should have been recorded immediately before the magistrate or concerned doctor, my lord. That is what, my lord, it should be, so that it does not have any doubtness, my lord, in the statement. And it should not be my lord, there should not be any tutoring or promptness or any sort of, my lord, biasness.
This
That is
statement was never executed also.
never exhibited, my lord.
Otherwise,
Although,
could be some kind of a dying declaration.
yes.
Sorry.
And second thing, my lord, it was recorded only on 4/6/2015.
He died on,
He died on 16/6.
oh, yes.
So it was not that imminent expectation of death that he was making the statement, and there is no possibility of making any.
In our law, I think that is not necessary. Circumstances surrounding is that. There's explanation to that.
That was recorded by police, my lord, at his home. But the fact remained that, my lord, when the incident took place, his statement was not recorded. And the PW1 and PW3, they are making statement that Doya Hamar told me so and so. Sorry, the victim told me that it is Doya Hamar. That is only, he has made this statement only on 4/6/2015. So basically, if the statement of the victim has no evidentiary value, my lord, then the other statement of the witnesses who could not identify the person, my lord, by his father name and address has not got any credible evidence, my lord. That is why, my lord, I am prejudiced, my lord. Person who is in behind a bar without the proper.
How long he's been?
Around, my lord, 2.5 years. My lord. And Only by a general presumption doya word.
He was on bail during the
No.
trial.
During the trial, my lord,
He was on bail.
I was on bail. Thereafter, after conviction and sentence was passed on, I was in jail from 2023 October, I think. And during trial,
Prior to that, you were on bail.
prior to that, I was on bail. 69 days. Sentence was imposed on 5th of
5th,
October
10.
2023. 5th October 2023, page 78.
Since then you are in jail.
Jail, my lord.
Hmm.
And my lord, one more thing, my lord. I have got the certified copy of the statement of the deceased, my lord. Recorded on 4/6/15 in Bengali version, my lord. It simply says only doya, my lord. And the two person he does not know.
Only doya.
Only doya. Doya, may I read, my lord? It's although in Bengali language. Amar নাম ও ঠিকানা উপরোক্ত মতে 28/3/2015 রাত্রি অনুমান 9টা সময় আমি বাড়ি যাওয়া পথে দয়া only দয়া ও দয়া and তাহার সঙ্গে নাম জানি না রাস্তায় আমাকে হত্যা করার জন্য মারে আরো অসচেতন অবস্থায় ফেলিয়ে দিয়ে এবং আমার জ্ঞান ফিরিয়ে আসিল কনসিয়াসিটি হাল্লা শিওর করি তাহার আমার আশপাশের লোকে আমাকে উদ্ধার করে neighboring people only rescued him, not his brother. That
was his statement when? 4/6.
4/6. When he was in home, my lord, after getting the treatment. There is a long gap from the date of incident to the. Their prosecution is silent regarding that. And between then, my lord, anything can happen, my lord. Change of person, change of everything. But even then, my lord, up to 4/6, my lord, whether Daini Singh is the Pudaiti is the Doya Hamar, nothing effort has been made. That is the thing, my lord, where I am prejudiced. Whether that is the person who is Doya Hamar, that could be identified in section 9. That was not done. That was the why, my lord, I am prejudiced.
Okay, that's all.
And that one more judgment I have, but later regarding dying declaration. It has to be in a fitness state of mind in presence of so and so.
You have given us one already, 2001 AR SCW,
Yes, I have given that.
para 29.
Era 29.
This is regarding IO,
Regarding IO.
dying declaration by IO,
Yes, yes,
recorded by IO. When there is no alternative at all, then
yes,
may be considered,
yes.
otherwise not.
And one by one. One more I have, my lord.
How many more?
Only one, my lord.
You're saying one more, and one after the other, you're taking out.
Cover that day, my lord, that my lord, that the statement, that means that the victim, court must be satisfied that the deceased was in a fit state of mind to make the statement and had clear capacity to observe and identify the assailant, and that he was making the statement without any influence or rancor. Once the court is satisfied that dying declaration is true and voluntary, it is sufficient. So he has to clear capacity to observe and identify. But he, even after 2.5 months, he stayed at Doya only. He did not say that it's a Dainishing Kudaiti and Doina Hammer of such and such village, and his father is so and so. And he used to be familiar with PW1 and nothing he has stated, my lord. That is the thing, my lord. And only word is Daya, my lord. And later on PW1 is, my lord, they are developing the other part that I know him for the first time in the dock. That is the thing, my lord, your lordship.
Oh.
If I am innocent, one is innocent, my lord. An innocent person should not. And the prosecution has to prove upon their own, my lord. Beyond reasonable doubt, they have to prove, my lord. An innocent person on presumption, my lord, keeping him as Doya, my lord.
You may be innocent.
My lord.
You may be innocent.
Yes.
You may not be innocent also.
May not be, but from the prosecution evidence, it appears that.
But then the burden of the prosecution is to prove it,
Yes,
isn't it?
yes.
You are saying that
Yes.
burden has not been discharged.
And why they, for this long period,
Identity crisis.
they have not exhibited a statement, my lord. It was basically on presumption, my lord. Presumption, they proceeded, my lord. But it is Doya. Dainishing is Doya.
Okay, you conclude your argument.
Yes.
Anything else?
That judgment later on I will give.
Okay, later on. Okay.
Proceed.
Mr. Kaushik.
First of all, Proceed, kindly, I will not go through the evidence part. My learned focus can show my question. PW1 and PW3.
Oh.
Who one is brother of the victim and other is the co-worker of the victim. Immediately when they went to the place of occurrence, the first thing the victim said, the Daya assaulted me along with others. Other person he could not recognize her. So from and PW1 statement, PW3 statement, it transpires that, my lord, they know the accused person. They recognize the accused person. Initial in their deposition, and I know the accused person present on the dock. PW1, PW3 also, I know the accused, namely Daya Hamar, so and so, present on the dock. So it shows that, my lord, the victim, PW1 and PW3, they are accustomed with the accused. So when they went to the place of occurrence, the victim immediately said, my lord, Daya assaulted us. Usually in real places or we among friends, we refer the person like that, so and so. Will the victim, when the victim says that somebody assaulted me, he will not give his postal address. He will not say that so and so, son of so and so, mother, his mother is so and so. He will not say. He will only say, this is the person. And my lord, interestingly, my lord, they have DW1, my lord. Page 25.
So in a way, you're saying that PW1 at the time of his deposition.
Yes.
He identified this
Daya.
Udaite
Udaite.
as the
Daya.
as the
As the PW3 also. And PW1 and 3. One is the co-worker and 3 is the brother of the my lord, the victim. So it transpires they knew the accused person from earlier. And my lord, PW1, my lord, page 25. As your lordship got it.
25, yes.
Page 25. My lord, here he said that I know the accused standing on the dock. His name is Dhyansiang Udai.
PW.
DW1.
PW.
25. Page 25.
He said that Dhyansiang Udai. Meaning thereby is the person who was standing on the dock. And that person, the accused, he in his 313 statement in page 39, and page 40. First, lordship may peruse page 39.
39.
Yes. Here, the examination of namely Dianxiang Pudai means the accused person. That Dianxiang Pudai in his 313 in page 40, he said that people of Diktasera market used to call me as Daya. He himself admitted that.
But only this may not be sufficient.
Only this may not be sufficient, my lord, but the only thing is the prosecution has done their part. They are denying. The burden lies upon them, my lord. The burden lies upon them. I mean, lordship has pointed out earlier. I should not repeat that in 313 general question can be asked. Incriminating materials, obviously that has to be put. Apart from that, general question can be asked. And there was nothing wrong in that. And regarding my lord, dying declaration, when police recorded the 161 statement, first of all, I'm sorry, lordship, I prepared the case here only, so I will not produce the case law. I will produce my lord. 161 statement that can be taken as dying declaration. There are now decisions.
No, but
Lordship may kindly
it was not executed.
not executed. That is
Exhibition
our-
is there, then at what stage it was taken? Injury happened long time back.
long time back, but the investigation
Is it the deceased died on a particular date?
because investigation was going on at that time. And police was not like it was police when police recorded the statement, although it is not executed, just for the sake of the query, police recorded the 161 statement, not with the anticipation that this person will die after 3-4 days. He recorded the 161 statement as a part of the investigation. Not in anticipation that this person will die XYZ day, my lord. So the submission made by my learned friend that regarding fitness of mind, all these things, that will not come. Because police was not recording dying declaration per se at that time. Police was recording 161 statement, which is a part of the investigation.
And after he died, it became kind of
Yes.
dying declaration.
After he died, it became dying declaration. It can be used as a dying declaration, but that has not been executed. That is recorded, and I cannot improve that. But the thing is that that statement also corroborates, my lord, the statement of PW 1 and 3 and the injury portion. Medical report, PW 7 statement, that also corroborates the version of PW 1 and 3, my lord. That injury alone and the 10-feet fall, the observation made by the PW 7 is 10-feet fall. And the statement made by the PW 1 and my lord PW 3 and the statement made by the victim before we can exclude the dying declaration per se 161 statement, but PW 1 and PW 3 statement remains. That oral dying declaration that corroborates with medical evidence. So far identity, because the main root cause of this case, now the question hinges on the point that whether this person is that person. That I showed, the prosecution showed that. Now they are disputing, it's up to them to show that this, no, I am not. If that happens, in every case, somebody said I am not that person.
Oh, so sometimes identity disputes do come up.
Yes, ma'am.
Whenever the identity disputes come up, this has to be resolved by the investigating authority and also by the prosecution to the extent possible.
To that extent possible. That,
So ideally when this thing came up, that most of the time it was alleged that Doya assaulted, Doya was the person. Then when the IO was sending up this
investigation
Udaite for the trial, there should have been some narration an investigation regarding this.
Yes, madam.
Regarding
That
that.
has to be. But the thing is that here Lordship has seen that that person was, he was initially referred to different hospital, madam. Then he came back. Ultimately, when police recorded his 161, after 3 days or 4 days, he died. 10 days. 10 days.
Like, just to draw a comparison, PW1 statement is better regarding identification.
Yes,
He says that I know the accused standing there.
yes.
So his name is Doya, not Doya Ma.
Doya.
But look at PW3. I know the accused, namely, some mistake in recording also.
Right.
I know the accused, namely Doya Ma, alias so and so to that.
Yes.
So without saying that this is his name.
Yes.
Straight away,
I
you cannot
know,
put the alias.
Yes.
But his statement PW1, it is better.
Better, madam.
That I know the accused, he is so and so.
Yes, madam. And why I
I know
showed,
him as so and so.
yes, madam. And why I showed DW1, because DW1 said that I know this, my lord, difficult to pronounce, madam. Ransiang Pudai.
Udaite.
And Pudaite said that I am Doya.
313.
313.
So it was none other than the same person on the dock.
They're the same person.
They say, we know him, we know him, we know him. He says he's Doya.
Yes.
Number one says he's also Doya, he's Doya Mar.
It's like, my lord, I said, man, I know X, my lord, but I didn't refer his pet name. But in his statement, he said, yes, I am X. I am also known as Y.
All this came only in the court only.
In the court only.
During the investigation, that was not there.
See, another thing is that in cross-examination of PW1,
There is no such.
that position is slightly diluted because he says that there could be some other person by the name of Doyamar.
My lord.
Doyamar one, so-called Doyamar
Doya.
is supposed to be the assailant.
SLN.
It has come out in various parts of the prosecution. But the most important question
Whether he is that
determine is that whether this person is that Doyamar who was the assailant. Assailant one. Whether
Yes.
this Udaite is the person Doyamar who was the assailant.
Yes.
That was
My humble submission, whatever I have showed, my lord, from that position, my lord, it is clear that that person is the. And this consistent, my lord, that oral dying declarations, 1 and 3. If we exclude the IO statement also, then these are consistent with the medical evidence. And it's not necessary, as Lordship already pointed out, imminent death is not necessary. Now the law has changed. That is my humble submission, my lord, because these are the main 2 points, if I am not wrong, my lord. It is their burden now to say that if they are denying something.
the original charge sheet.
And my lord, PW 1 and 3, there is no suggestion that this Doya Hamar is not that Doya Hamar. There is no suggestion.
PW1, the position, see, say, apart from saying, I know Doya Mar. Beyond that, there's nothing. In the cross-examination also again, says, I know Doyamar from before the incident. But it doesn't go on to explain why, how he knows and who is he, from which place.
That is not.
That is not there.
That is one. Whether this Udaiti is the assailant Doyama.
Yes, ma'am.
There may be more than one Doyama. So yes, okay,
Maybe.
it's not.
Maybe. And that.
In the sent up charge sheet, written Udaiti alias Doyama.
Madam?
In the charge sheet also,
Yes.
I have said this Udaiti alias Doyama.
Elias there. Well, that is, but these suggestions were not put to them. These suggestions were not put to them. And only thing is that my lord, PW 1, 3 and the disease, as I already stated, my lord, they already knew this person. That's why the victim said that Daya.
Certain statement he himself has said,
He himself
1.3,
said, my lord.
that there is no other person by the name Doya
Yes.
in his village.
Yes. And why I pointed out DW1 because DW1 already said this. Pudait, my lord. And Pudait said, I am Doya Hamad.
But he also says in 313 that I do not have any other nickname, another name. I do not have any other name.
Right.
And he says that in village he is called Doya.
To the specific question put to him, is your nickname as Daya in your village? He said yes.
He is known as Daya in Ditkochera. People of the Ditkochera market call him Doya.
And the incident happened in the Tiktochera market.
And whereas in his hometown, I think it's known as Deinisang. And they call him Sanga.
So some.
Hmm. What was the requirement to have the 313 again after a lapse of 3 months again? Not 3 months, 6 months.
6 months.
No, sorry, not 6 months. Where's that? 150.
To take the order sheet.
9 February 23. First one. Second one is 21st July 23.
But the question is how they are prejudiced. He is prejudiced otherwise. They have not shown that they are prejudiced. He has a right to be silent.
That to be silent.
Yes.
313 was probably conducted only for purpose of that identity.
Identity only. So
But
everything is happening in
Why
the
not
court.
the questions are specific to that point?
Everything is happening in the court.
Yes. Why my humble submission that my lord has been true, but their duty now to say that I am not that person. But they are denying. But in 313, he himself admitted. And regarding this dying declaration, PW 1-3, as well as my lord's statement of the IO, coupled with the medical report, that corroborates. Single dying declaration can be sufficient.
The trial court has taken it as a dying declaration,
Madam.
161.
No, but because, yes,
The
madam.
man it was appreciated,
Yes,
I think it was more or less taken as a 161.
161.
I mean, 161 was taken as a dying
Dying
declaration.
declaration, page my lord 69, whereas 27.1.
Since the 161 statement is generally hit by the bar in 162.
2.
Therefore, for the purpose of using it as a dying declaration, it was all the more necessary to exhibit.
Yes, that is law. Like, but if we leave aside this portion also, based on statement of 1 and 3 and medical evidence, and that statement, the deposition portion of the IO can be taken. That he said that. That is leaving.
What do you say about the conviction under 302? Ingredients have been satisfied.
My lord, going by the injury, my lord is satisfied because the cervical bone is very strong. And regarding my lord specific overt act, my learned friend stated that my lord who assaulted who, because if there are multiple persons, and a specific overt act is not necessary in the case of murder. I will place the judgment.
Okay. Anything else?
These are my humble submissions.
Anybody else is a party here?
I am appearing for the informant.
Yes, what is your submission?
My lord, in fact, my lord, due to oversight in the daily policies, my lord, I could not follow that the matter is listed today before this honorable court, my lord. My lord, now I am informed, my lord, that the case is listed today for hearing. So, my lord, I could not prepare. If your lordship, my lord, a short accommodation, my lord, let it keep as part heard, my lord, day after tomorrow. I shall. Sorry. Monday or Tuesday next, my lord. Let it be kept as part heard, my lord. My lord, because I have to, my lord, do my homeworks as well as the authority, my lord, of the Supreme Court on this point, my lord. I have heard my the argument of my learned friend as well as my friend appearing as public prosecutors.
See,
Now,
we understand your difficulty, but the problem is that our difficulty is also there. That constitution of this bench is a bit special. It is a special DB. Again, this is a more special DB, since we are not the regular ones. So we have very limited time. And that's why in the morning also another matter was adjourned.
Tomorrow, will it be possible for you?
Otherwise, my learned PP has covered his part. He's a formal party only. It's not a posto case.
Tomorrow. I'll prepare today. Tomorrow at 2 p.m. Mila.
By 2 p.m. Supposing there's no there's no case tomorrow, then from morning we'll sit idle and come at 2 p.m.
All right, as your lordship pleases.
It may reach earlier also.
Yes, I like it.
See, your friend Mr. Kaushik, no?
Otherwise, my lord, he has covered all aspect of the matter, my lord. 2-3 points I like to add, my lord.
On the spot, he is prepared and submitted.
Yes,
You could have prepared on the spot.
Just now I have been told, my lord. I rushed, when my friend started. So,
Tomorrow, brother. All right. Tomorrow then.
uh,
Then, my lord, tomorrow I'll place two more judgment. my lord.
Yes, you do that. And I think Mr. Kaushik also wants to place something.
I also.
All right. This is item number.
I already mailed my, but that's wrong judgment.
Okay. Mr. B. Barua, learned counsel for the appellant, and Mr. R. R. Kaushik, learned additional public prosecutor, Assam, have made their respective submissions. Stop. However, Mr. A. Hassan, A. Hussain,
My lord, BK Shen.
I'm sorry, BK Sen. How do you pronounce? Shen,
My lord,
not Sen. Oh, Shen.
Asian.
Shen. Mr. BK Shen, learned counsel for the respondent number 2, submits that he will make his submissions tomorrow. Give the date. In view of above, list this matter again tomorrow as part heard. Liberty to the parties to submit their respective authorities. To submit authorities, not respective, submit authorities in support of their case.
Right.
Oh, sorry, this was also.
Item 11.
My lord, I'll submit on 4 counts, my lord, the judgments. First is extrajudicial, I'll cite the judgments on extrajudicial confession. Second, I'll cite on section 27, recovery of the weapon, my lord. That was not from me, my lord. Third part is that 106, my lord. It says that if it is in the 4 walls of an house, if something happens, my lord, then the person has to give a reasonable explanation under 106, my lord. To that, my lord, I'll place one judgment of the Honorable Supreme Court, led by 3 judge benches, my lord, which says that the prosecution has to lead its evidence and prove the case beyond reasonable doubt. Thereafter, only the reasonable explanation and plausible explanation from the accused will be required in the 106. So these only 3 count. In 4th part, my lord, the weapon of assault was not sent for FSL, my lord. The reason that is fatal to the incident once the IO says that the blood stain was there. So, my lord, this only on 4 count, my lord.
Yes.
Okay, my lord. 1997, 1 SCC. Now, my lord. Para 20, my lord. Relevant. Only relevant part I'll read out, rest I'll not.
Para 20.
Para 20, my lord. Internal page 4, my lord. May I read, my lord?
Yes.
The other reasoning based on section 26 of the Evidence Act is also fallacious. It is true any confession made to a police officer is admissible under section 25 of the Act, and that ban is further stressed through section 26 to the confession made to any other person, also if the confessor was then in police custody. Now, my lord, this is important. Such custody need not necessarily be post-arrest custody. If any accused is within the keen of surveillance of the police during which his movements are restricted, then it can be regarded as custodial surveillance for the purpose of this section. Another important part, my lord, if he makes any confession during that period to any person, be he not a police officer, Such confession would also be hedged within the band contour outlined in section 26 of the Evidence Act. So, my lord, my first part of submission is in this regard is that initially, prior to the police coming to the place of occurrence, my lord, I was kept confined by the villagers. I was assaulted. And there they said that I made a confession before public and thereafter before the police office. So only this part. Since my movement was restricted, my lord, so my lord, this part I'm placing this aspect, my lord. Second, I'm to go.
So in a way, this, does it mean that, the 25 is confession to a police officer, right? So, in a way, this could mean that 26 covers the case of a confession made in the presence of a police officer.
Yes.
But it will be admissible only if it is, if a magistrate is also present at the same time.
Yes, yes, that part is there. That part is there.
Otherwise, no.
Now, my second judgment I'm placing. My lord, para 9. This also with reference to the extrajudicial confession, my lord. This was a 3-bench judgment of the Honorable Supreme Court, my lord.
There are 9.
Para 9, my lord. Internal page 3, my lord. May I read, my lord?
Yes.
Section 25 of the Evidence Act is one of the provision of law dealing with confessions made by an accused. The law relating to confession is to be found generally in section 24 to 30 of the Evidence Act and section 162 and 164 of the Code of Criminal Procedure 1898. Section 17 to 31 of the Evidence Act are to be found under the heading admissions. Confession is a species of admission and is dealt within section 24 to 30. A confession or an admission is evidence against the maker of it, unless its admissibility is excluded by some provisions of law. Section 24 excludes confessions caused by certain inducement, threats, and promises. So, my lord, there I was beaten, my lord. I was in the threat, my lord, of my life. So, Section 25 provides no confession made to a police officer shall be proved as against a person accused of an offense. The term of section 25 are imperative. A confession made to a police officer under any circumstances is not admissible in evidence against the accused. It covers a confession made when he was free and not in police custody, as also a confession made before any investigation has begun. The expression accused of any offense covers a person accused of an offense at the trial, whether or not he was accused of the offense when he had made the confession. Section 26 prohibits proof against any person of a confession made by him in the custody of a police officer unless it is made in the immediate presence of a magistrate. The partial ban imposed by section 26 relates to a confession made to a person other than a police officer. Section 26 does not qualify the absolute ban imposed by section 25 on a confession made to a police officer. Section 27 is the form of a proviso and partially leaves the ban upon section 24, 25, and 26. It provides that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in custody of a police officer, so much of such information, whether it amounts to a confession or not, as relate distinctly to the facts thereby discovered may be proved. So, my lord, 27 has also been taken care of. Had I led to the discovery of the weapon, my lord, then it could have been an admissible part. But here is a case where the PW 2, 4, 6, and 7 says that I was assaulted. Now PW 2 says that I handed over the dao. PW 4 says that police seized the dao by the side of the body. And PW 6 says that accused brought out the dao by which he stabbed. He brought the dao inside from the house or somewhere. But it does not say that he went down to 2 kilometers and from there The police took him to a place and from there he brought it. Section 162 of the Code of Criminal Procedure forbids the use of any statement made by any person to a police officer in course of an investigation for any purpose at any inquiry or trial in respect of the offence under investigation, save as mentioned in the proviso, and in cases falling under subsection 2, and it is specifically provides that nothing in it shall be deemed to affect the provision of section 27 of the Evidence Act. The words of section 162 are wide enough to include a confession made to a police officer in course of an investigation. A statement or a confession made in course of an investigation may be recorded by a magistrate under section 164 of the Code of Criminal Procedure, subject to the safeguard imposed by the section. Thus, except as provided by section 27 of the evidence, a confession by an accused to a police officer is absolutely protected under section 25 of the Evidence Act, and if it is made in course of an investigation, it is also protected by section 162 of the Code of Criminal Procedure, and a confession to any other person made by him while in the custody of a police officer is protected by section 26, unless it is made in the immediate presence of a magistrate. These provisions seems to proceed upon the view that confessions made by an accused to a police officer or made by him while he is in custody of a police officer are not to be trusted and should not be used in evidence against him. They are based upon grounds of public policy and the fullest effect should be given to them. So as rightly pointed out by my Lord Justice Das, my Lord, that has to be immediately before a magistrate. If it is not there, my Lord, then in that case, my Lord, it will not be reliable, my Lord. Now, my Lord, I'll take your Lordship. This is a recent Supreme Court judgment, which was authored by the then Chief Justice of India, Sanjeev Khanna, para 19, 22, and 23. 2024 1 SCR 87. Perumal Raja, alias Perumal, versus state represented by Inspector of Police. Para 19, internal page 8, my Lord. The prosecution's case in absence of eyewitness is based upon circumstantial evidence. As per section 25 of the Indian Evidence Act 1872, a confession made to a police officer is prohibited and cannot be admitted in evidence. Section 26 of the Evidence Act provides that no confession made by any person while he is in the custody of a police officer shall be proved against such person unless it is made in the immediate presence of a magistrate. Section 27, how much of information received from an accused may be proved, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved of the Evidence Act in an exception to section 25 and 26 of the Evidence Act. It makes that part of the statement which distinctly leads to discovery of a fact in consequence of the information received from a person accused of an offence, to the extent it distinctly relates to the fact thereby discovered, admissible in evidence against the accused. The fact which is discovered as a consequence of the information given is admissible in evidence. Further, the fact discovered must lead to recovery of a physical object, and only that information which distinctly relates to that discovery can be proved. Section 27 of the Evidence Act is based on the doctrine of confirmation by subsequent events. A fact is actually discovered in consequence of the information given, which results in recovery of a physical object. The fact discovered and the recovery is an assurance that the information given by a person accused of the offence can be relied. Then, my Lord, 27 is on the exact point, my Lord. And 23 also, my Lord. 23 is important, my Lord. Page 9, my Lord, para 23.
Yes.
The facts proved by the prosecution, particularly the admissible portion of the statement of the accused, would give rise to two alternative hypotheses, namely that the accused has himself deposited the physical items which were recovered, or number two, only the accused knew that the physical items were lying at that place. The second hypothesis is wholly compatible with the innocence of the accused, where the first would be a factor to show involvement of the accused in the offense. The court has to analyze which of the hypotheses should be accepted in a particular case. So now, my lord, here in my case, my lord would appreciate that the seizure witness, PW 8 and 9, PW 8 says that it was lying left side of the road, my lord. He was called, he signed in a blank paper, my lord, and his house and the house of the accused has 2 kilometer distance. And he does not even say that accused was present at the time when the weapon was seized. And PW 9, thereafter, he says that he went to the place of occurrence at about 9. The dao was recovered at 1 a.m. prior to the incident, if it is taken, or thereafter on the next day, my lord, at midnight. And his signature was taken in the office, and he cannot remember what was written in the seizure list. Now, my lord, a judgment of our High Court only, my lord, on the point that the weapon of assault should be sent to forensic, my lord. Para 15, my lord.
Para
15. Internal page 4, my lord. Internal page 4, my lord. Para 15. PW1 stated that on the following day, police recovered a dao being the weapon of offense. The PW6 stated that Motilal Garg confessed before the police that the dao used in the offense was kept concealed under a pillow. PW6 further stated that though the accused led the police to the place where the dao was kept hidden, no dao could be found under the pillow. But later on, the brother of the accused had shown the place where the dao was hidden, and thereafter the police recovered the same from the jungle near a pond. According to PW7, he accompanied the police to the house of the accused Motilal Garg, and on being asked, the family members of the accused Motilal had shown the place where the accused has concealed the dao, and thereafter the police recovered the dao from the jungle near a pond. PW8, the investigation officer deposed that on the basis of the disclosure statement of the accused appellant Motilal, he recovered the dao from a pond which was seized by the Exhibit 6. What is evident from the oral testimony of this witness, including the investigation officer, is that a dao was recovered on being shown by the family members of the appellant Motilal Garg. However, the said dao was not sent for forensic and serological test. Although all the witness stated about the matched dao, the seizure list Exhibit 6 shows that the dao seized by the police was a Kamati dao. Be that as it may, on the basis of the evidence on record, more particularly the testimony of the seizure witness, it cannot be said for certain that the alleged dao was recovered on being led by the appellant. Evidently, the seized dao was not sent for chemical or serological test. In absence of chemical and serological test of the so-called weapon of offense, mere recovery of the weapon dao may be of no use to the prosecution in the present case, in as much as there is no evidence on record to connect the dao seized by the Exhibit 6 with the commission of the offense. True, it is the lapse on the part of the investigation officer or non-examination of the weapon by chemical expert for serological test may not in all cases affect the prosecution. But in a case which rests solely on the circumstantial evidence, unless the weapon of offense is subjected to serological test, prosecution would be deprived of any link evidence to connect the weapon with the commission of offense. Therefore, in the present case, non-examination of the weapon for serological test is fatal for the prosecution. In absence of serological test, prosecution is left with no evidence to connect the seized dao with the commission of offense. Therefore, in our considered view, the so-called recovery of weapon in the instant case is also of no use to the prosecution in absence of chemical test. So, my lord, what lordship would appreciate the IO PW10, my lord. He only says that then I seize one dao and small half burnt material from the place of occurrence were found lying. So place of occurrence is the house, not the place of residence of the PW8 Kanak Sharma, who is the seizure witness, my lord. And the IO says that there was blood stain on the dao. Once that part was there, and because of the fact why I'm saying so is that, my lord, PW8 and PW9 has specifically stated in the code that at present, I cannot say whether there was any blood stain on the dao. And he also says, police seized the dao in presence of me and obtained my signature. At that time, I came to know that the accused has caused murder to his wife by giving the blow of dao. I could not identify the dao produced before me, which was seized in my presence. So they have not confirmed in the court that this is the same dao which was recovered on that particular day. Now, my lord, the last judgment I place, the recent judgment of the Honorable Supreme Court. Anish versus the state government of NCT. 2024, 6 SCR 164. My lord, this judgment speaks on two counts, my lord. One is that if something has happened in the four walls of a house, my lord, I must make a reasonable and plausible explanation. And the second part, the judgment says that the prosecution has to first prove the case beyond reasonable doubt, then only my reasonable and plausible explanation will come. My lord, will directly come to page 188, my lord. 188, my lord, page number 188. Para 38, my lord. Because in this case, my lord, there are altogether 60 judgments cited, my lord, in this judgment. One of the leading judgment on the point of 106, my lord, at present. Para 38, my lord, page 188. The aforesaid decision Sambhunath has been referred to and relied upon in Nagendra Shah versus State of Bihar 2021 10 SCC 725, wherein this court observed as under. Thus, Section 106 of the Evidence Act will apply to those cases where the prosecution has succeeded in establishing the facts which reasonable inference can be drawn regarding the existence of certain other facts which are within the special knowledge of the accused. When the accused fails to offer a proper explanation about the existence of said other facts, the court can always draw an appropriate inference. When a case is resting on circumstantial evidence, if the accused fails to offer a reasonable explanation and in discharge of burden placed on him by virtue of Section 106 of the Evidence Act, such a failure may provide an additional link to the chain of circumstances. In a case governed by circumstantial evidence, if the chain of circumstances which is required to be established by the prosecution is not established, the failure of the accused to discharge the burden under Section 106 of the Evidence Act is not relevant at all. When the chain is not complete, felicity of the defense is no ground to convict the accused. Then, my lord, at para 39, the underlying portion I'm reading only. It empowers the court to presume the existence of an effect which it thinks likely to have happened In that process, the court shall have regards to the common course of natural events, human conduct, etc., in addition to the facts of the case. In these circumstances, the principle embodied in section 106 of the Evidence Act can also be utilized. We make it clear that this section is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt, but it would apply to cases where the prosecution has succeeded in proving the facts from which a reasonable inference can be drawn regarding the existence of certain other facts, unless the accused, by virtue of his special knowledge regarding such facts, fail to offer any explanation which might drive the court to draw an inference, different inference. So, my lord, here in this case is purely based upon circumstantial evidence, my lord. And one part your lordship would appreciate, under 313, this was not put on me that from this time to this time where I was. However, my lord, there is an omission on the part of this accused that he also did not describe that from 8 p.m. till 5 p.m. where was he? That explanation the accused has not made, my lord. But however, my lord, the extrajudicial confession is tainted because he was assaulted. That part has come, my lord, in the evidence. Second part is that, my lord, the weapon was recovered from some other place, and it was not led by the accused to the discovery of the said physical object, my lord. Third part is that when the weapon of assault, because the witnesses says that we cannot say exactly this is the weapon which was used in the assault. So, my lord, if by going by the witnesses, if a dao was found at the place of occurrence and a dao found subsequently, which was seized in presence of PW 8 and 9, in that case, my lord, the dao should have been sent to the serological and chemical test, my lord, in order to verify whether the said weapon was used for committing the assault. That part is also missing. So this is my humble submission, madam. I sum up with this submission. I'm deeply obliged for giving a patient hearing, madam.
Yes.
Although my learned friend has taken plea as regards 106, as regards lordship, the seizure of weapon of offense, lordship, I will not make any such to counter his argument here, lordship. All those points I will not take, because 106 according to me is not attractive, my lord, and seizure lordship as per procedure as envisaged in section 27 is not attractive. So my case is only on the point of extrajudicial confession, whether on the basis of extrajudicial confession made in the instant case, the accused appellant can be lordship convicted, your lordship. First, I'll take your lordship to the evidence of PW2, your lordship. Dominic Orang, he is the person in whose residence the occurrence had taken place, my lord. PW2, page 10. I am the informant. I know the accused Atua Munda, who is the father-in-law of my cousin's son of my elder sister. The incident occurred on 22/1/19. On the day of incident, I was staying at my basti at Uttar Goria Jhar, Jorabasti, as I was looking after my cultivation at Jorabasti. During the time, I asked accused Atua Munda to stay in my original residence in line number 2, house number 55 at Orangjuli Tea Estate. So the residence is of PW2, your lordship. It was not accused appellant's own residence, my lord. However, at about 4 p.m., Rajan, who is my next door neighbor at Jorabosti received a phone call that there was a murder in my residence and my house was burning. Rajan immediately conveyed this message to me. Hearing this, I, along with Rajan, immediately rushed to my original house in my own scooty. On reaching the spot, I saw my entire house gutted with fire, and the body of Regina Munda, wife of Atua Munda, was found lying on the courtyard of my house with cut injury on her neck. Having seen the scene, I was almost broken down as my house was already burned. After a few minutes thereafter, accused Atua Munda came to my house. It is to be noted that before I reached the spot, police personnel and villagers already gathered there. Then accused Atua Munda confessed before the public and the police that he committed the crime. Accused Atua Munda also handed over a dao to police with which he committed murder of his wife. Police then seized the dao, but I did not sign in the seizure list as witness. During investigation, police also recorded my statement under so and so. In cross, I did not see the incident who committed the crime. Accused led the police where he kept the offending dao hiding and then shown the same to police who seized the dao. It is not a fact that I did not state before the police that accused Atua Munda confessed about the commission of crime in presence of public and police. It is not a fact that the accused did not commit the murder and I deposed falsely. Although he says in presence of police, the accused where he has hit this one, weapon of offense, Lordship, but from the evidence of PW6 here, Lordship may kindly have a look at the evidence of PW6, my lord. Basil Chapna. Lordship, before the arrival of the police, your Lordship, fourth line from the bottom, not from bottom, portion of the examination chief minor. Accused arrived at the place and on question made by the villagers, the accused brought out the dao by which he had given stab injury on the neck of his wife. Accused confesses guilt before public, then police was called. So before the arrival of the police, the weapon of offense was recovered, your Lordship. So, Lordship, it not be admissible, my lord. My submission, I may be wrong in submitting, my lord, but Lordship, this teaser and discovery of the weapon, Lordship, may not be attracted, my lord. And as regards the other part, your Lordship, whether they used to live together as husband and wife during the relevant point of time in the same house, only from the mouth of Io it came, your Lordship. None of the witnesses have deposed that the victim was with the accused person at the place of occurrence. So what remains is the extrajudicial confession, my lord. Now I rely on the evidence of PW 4 and 5. PW 4, page 14. I know the informant Dominic Orang and also accused Atua Munda. I also know this is Regina Munda. The incident occurred on 22/1/19 at about 3 a.m. I was just sleeping in my house. My house is adjacent to the house of accused Atua Munda. Then I heard Atua Kachua shouting as fire, fire. Hearing him, I got up from my sleep and ran towards the house of Atua Munda. Then I saw the fire from the house of Atua Munda is gradually engrossing towards the house. So towards our house. So I climbed to the roof of our house and put out the fire by throwing water with bucket. In the meantime, our neighbors, Sankar Driver, Bir Singh Sangha, Junas Triki, Raju Munda, etc. were present, who also assisted in extinguishing fire. Thereafter, fire brigade party as well as welfare officer Aurangzili also reached the spot. Then after entering inside the house of the Atua Munda, the neighbor Jacarias and Jogan brought out the wife of accused Atua Munda from inside the house with cut injury on her neck, and she was dead by this time, but her husband accused Atua Munda fled away. At around 5 a.m. when people were gathering in the house of Atua Munda came and confessed in my presence as well as in presence of other villagers, namely Sankar Driver, Bir Singh Sangha, Junas Tiki, Raju Munda, Jakaria, Jogan, Robin Gola, the president, all of some Adivasi student union, etc., that he cut the throat of his wife with kalam katari on instrument made of iron used for cutting tea planted. Thereafter, he fled away by setting the house on fire. Then Robin Gola informed the matter to police. So, Lordship, may I pause here? There are two parts. First, he confessed before PW4, then he went away. Then again, he came back when the police arrived. So at the time when he confessed before PW4, there was no police. As my learned friend was trying to project your lordship there was lordship coercion, threat, and lordship, he was assaulted by the villagers. It was not my lord.
PW4.
Lordship, PW4 and PW5.
No, when he made the confession.
Yes, before
As
PW4.
testified by PW.
There are two parts, my lord. He made the confession, went back, again came back when the police arrived. Lordship, examination chief last part. Then accused Atwamund was handed over to police. Then lordship, prior to that, then Robin Gola informed the matter to police. So there are two parts, lordship. May I submit? First, he made before PW4 and 5. That time police was not there. Then thereafter he again came back. That time police was there. So my responsible submission is that the extrajudicial confession before PW4 and PW5 would be admissible in evidence because it is not out of lordship influence or coercion or threat, your lordship.
Cross-examination
Lordship.
says that when the accused made the confession. before
Yes.
public, Police personnel were also.
Yes, so my.
Second time.
Yes, second time. Now let us see the evidence of
And my lord,
PW5.
he also says that he was assaulted.
Yes, later on.
Last 3 lines above, my lord, the cross. I have heard that before accused made the confession, he was assaulted by the public gathered.
Yes, that time all public gathered, my lord. When he made the statement before the public, that time he was assaulted. So prior to that, your lordship, whatever he stated before PW4 as well as PW5, it would be admissible in evidence. Now let lordship, may I take your lordship to evidence of PW5?
You are referring to PW4, isn't it?
Yes, lordship.
And the other one?
PW5. Page 16.
Before police.
Yes.
Before police
No,
came.
no, it was
Before police arrived.
Yes, your lordship. PW5. I know the informant, page 16, your lordship. I know the informant as well as accused. I know this is Regina Munda. The incident occurred on 22/1/19. At about 3 a.m. while I was coming out in response to a call of nature, I saw fire engrossed the house of accused Atua Munda. Then I shouted as fire, fire. The neighbor, namely Dominic Orang, Sankar Raju, Jakaria, Jogan, Paresram Munda, Philip and Robi, along with few other villagers gathered there. Jacarias and Jogan brought out the dead body of Regina Munda from inside the house with cut injury on her neck throat. I assisted in putting out the fire. Later on, accused confessed before the public about killing his wife. I also heard accused making the confession. Accused fled away after setting the house on fire. Around 5 p.m., accused came back to his house and admitted his guilt. Police came and recorded my statement. Then your lordship cross. I have not seen who set fire on the house of accused. I have not talked with accused. Accused was not threatened or assaulted the public on the day of incident. Police was present while accused made the confession of killing his wife and setting his house on fire. My house is adjacent to the house of accused. Accused came back to his house later on after the fire was put off. It is not a fact that I stated before the police the accused made the confession before me as well as to other public. I have not seen the dead body. I do not know whether accused voluntarily made the confession or at the threat and pressure of public. Robin Gola and welfare of the tea garden also came. I do not know whether Robin Gola assaulted or threatened the accused. So even if your lordship discards evidence PW5, the evidence of PW4 still remains, your lordship. Because from his statement, it's not that clear on evidence. But PW4 is clear because from lordship in front of whom the extrajudicial confession was given, he fled back again, he arrived, your lordship. Now, on the basis of the statement given by the accused person before PW4, whether can conviction be upheld, your lordship? I'll make the submission and I'll refer to one judgment to the effect. 2012, 6 SCC 403. Only one judgment.
2012.
6 SCC 403. Para 14 to 16.
Extrajudicial confession.
Yes. Para 14.
So there are two groups,
Lordship.
4 and 5 before police came,
Yes.
2 and 3 after police came.
Yes. And admittedly, 106 probably will not be attracted because they were not, it was not, nobody has said they lived together in that house during the very point of time. Apart from police, my IO, from whom he has come to know nothing is discernible from the evidence, Your Lordship. So 106, my respectful submission, it will not be attracted, my lord. Para 14. It is a settled principle of criminal jurisprudence that extrajudicial confession is a weak piece of evidence. Wherever the court, upon due appreciation of the entire prosecution evidence, intends to base a conviction on an extrajudicial confession, it must ensure that the same inspires confidence and is corroborated by other prosecution evidence. If, however, the extrajudicial confession suffers from material discrepancies or inherent improbabilities and does not appear to be chosen as part of prosecution version, it may be difficult for the court to base a conviction on such a confession. In such circumstances, the court would be fully justified in ruling such evidence out of the consideration. Now, we may examine some judgments of this court dealing with this aspect. In Balwinder Singh versus State of Punjab, this court stated the principle that an extrajudicial confession by its very nature is rather a weak type of evidence and requires appreciation with a great deal of care and caution. Where an extrajudicial confession is surrounded by suspicious circumstances, its credibility becomes doubtful and it loses its importance. In Pakiri Sami versus State of Tamil Nadu, the court held that it is well settled that it is a rule of caution where the court would generally look for an independent, reliable corroboration before placing any reliance upon such extrajudicial confession. Again, in Kavita versus State of Tamil Nadu, court stated the dictum that there's no doubt that conviction can be based on an extrajudicial confession, but it is well settled that in the very nature of things, it is a weak piece of evidence. It is to be proved just like any other fact, and the value thereof depends upon the veracity of the witnesses to whom it is made. While explaining the dimensions of principles governing the admissibility and evidentiary value of an extrajudicial confession, the court in State of Rajasthan versus Rajaram stated the principle that an extrajudicial confession, if voluntary and true and made in a fit state of mind, can be relied upon by the court. The confession will have to be proved like any other fact. The value of the evidence as to confession, like any other evidence, depends upon the veracity of the witness to whom it has been made. The court further expressed the view that such a confession can be relied upon and conviction can be founded thereon if the evidence about the confession comes from the mouth of witnesses who appear to be unbiased, not even remotely inimical to the accused, and in respect to whom nothing is brought out which may tend to indicate that he may have a motive of attributing an untruthful statement to the accused. In Aloknath Datta State of West Bengal, the court, while dealing the placing reliance of on extrajudicial confession by the lower courts in absence of other corroborating material as unjustified observed. Confession ordinarily is admissible in evidence. It is a relevant fact. It can be acted upon. Confession may, under certain circumstances, and subject to law laid down by the superior judiciary from time to time. From the basis for conviction, it is, however, tried that for the said purpose, the court has to satisfy itself in regard to voluntariness of the confession, truthfulness of the confession, and corroboration. A detailed confession, which should otherwise be within the special knowledge of the accused, may itself be not sufficient to raise the presumption that confession is the truthful one. Main features of the confessions are required to be verified. It is not done. No conviction can be based only on the sole basis thereof. Accepting the admissibility of extrajudicial confession, the court in Sansar Chand versus State of Rajasthan held that there is no absolute rule that an extrajudicial confession can never be the basis of a conviction. Although ordinarily an extrajudicial confession should be corroborated by some other material. In the present case, the extrajudicial confession by Balwant Singh has been referred to in judicial. In this case, it was dismissed, Your Lordship, but I'll be referring the paragraphs as I have cited, my lord. So from the evidence of PW4, your lordship, I may make the submission that it was the extrajudicial confession made by the accused person before before PW4 was voluntary, was truthful, your lordship, and the defense could not prove anything to challenge the extrajudicial confession made by the accused person that this witness was an inimical term with the accused person. And it was biased towards him, your lordship. Regarding the 106 lordship, the duty was cast on the accused person to prove, your lordship, to make a statement in 313 that he was not with lordship the victim at a relevant point of time. But at the same time, lordship, as I have made the submission, 106 will not be attracted in an instant. But nobody could prove the case that, your lordship, they were in four corners together, my lord, the house. Regarding the defect in the investigation, your lordship, that it was not sent for forensic. I don't think it's fatal to the prosecution case. If the lordship, if the prosecution could stand on its legs, your lordship, then all these defects and lordship, it's a curable defect. Apart from that, I don't find any other material in favor of the prosecution, your lordship. So I make a submission, your lordship will judge whether the evidence given before PW4 and 5 is lordship is enough to upheld the conviction. That is my respective submission.
My lord, in reply, I'll just place one judgment. I was not willing to place that, but I'm just placing for a reason, my lord. On extrajudicial confession, my lord, recent Supreme Court judgment, 2023, my lord. 2023 to SCR 875, my lord. Small paragraph, my lord. Para 5, my lord. Page 877, my lord. The reason why I'm placing, my lord, good. Page 877.
Yeah.
Para 5, my lord. As far as extrajudicial confession is concerned, the law is well settled. Generally, it is a weak piece of evidence. However, a conviction can be sustained on the basis of extrajudicial confession, provided that the confession is proved to be voluntary and truthful. So, my lord, he was assaulted. That was not voluntary. It should be free of any inducement. The evidentiary value of such confession also depends on the person to whom it is made. This is important, my lord. Going by the natural course of human conduct, normally a person would confide about a crime committed by him only with such a person in whom he has implicit faith. Normally, a person would not make a confession to someone who is totally a stranger to him. Moreover, the court has to be satisfied with the reliability of the confession, keeping in view the circumstances in which it is made. As a matter of rule, corroboration is not required. However, if an extrajudicial confession is corroborated by other evidence on record, it acquires more credibility. So, my lord,
So
basically,
lordship,
but this what the exact the judgment says here, to whom I repose confidence, I'll make confession to those. Now, my lord, the evidence what has come is that I have not been the residence of this house. It is the house of Dominic Oran. I have been asked to stay there. So, my lord, these persons who are my neighbors are not someone whom I implicit faith on them. They are strangers to me. This is what I'm trying to place. And rest, my lord, other part what I'll play is that, my lord, all the PWs on presumption, they are saying that the accused after killing has left. This is their presumption because they, on the verge of I being the husband, they are feeling that I had been there in the place, I have killed, and there after burning the house, I have left. But nobody has seen the evidence. Nobody has seen the occurrence, my lord. So this what has come from the London mouth of the London Senior Council, my lord, that everybody has said that first I left and thereafter again I came back. That is not the case. That is only on the presumption line. That it was me who had killed and thereafter burned the house and left. So that presumption they are throwing in the showing that light that I was there, I killed, I burned the house, I left, and thereafter, when the public and the gathered there, I came back, and thereafter, I made the confession, my lord. And most important part, my lord, the IO, the cross part of the IO, one part is there wherein it says that I did not seize the clothes of the victim. It should have been the clothes of the accused, my lord, to my very understanding, my lord. I'll just show that part, my lord. In the cross part, my lord, find page 28, my lord. Eighth line, my lord. Initially, he says that the seized dhow was not sent for FSL examination, though there was blood stain on the dhow. I did not take any steps for fingerprint examination of the dhow. I did not seize any cloth which was used by the accused. Or it is written as victim. It should have been accused, my lord.
Victim also.
It can be victim also. But this is my.
Lordship, regarding the presumption, as my learned friend is submitting, my lord, and whatever citations he has placed, it goes in my favor, my lord. Nothing, the extrajudicial confession made before PW4 was not challenged. In 313 also, he was silent that this PW4 was in inimical terms with him, my lord. And as such, he had made that submission. He has given that evidence. Nothing has been cited. And presumption, my lord, 114 of the Evidence Act, court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regarding to the common course of natural events, human conduct in public and private business in their relation to the facts of the particular case. So it can be presumed from taking into account the entire evidence on record that the accused is the perpetrator of crime. Because he could not prove in contrary, my lord.
That is why, my lord, I placed that custody part, my lord. The first judgment I placed because I was in custody of the public. My movement was restricted. And after the arrival of police, again, my lord, my movement was restricted, my lord. Oblige your lordships.
Lordship, I don't find any compensation is awarded, but to whom it would be awarded, my lord? Wife died, any sibling, nothing is there. Oh, sentencing. Victim compensation. Sentence hearing to slide.
Yeah, no, my lord, no such, my lord. Compensation is awarded. Compensation was not awarded, my lord. বাচ্চাও তেনেকা দেখুৱা নাই বাচ্চা আছে বুলি
Any indication about the family?
No, my lord, no indication, nothing has come, either children or anybody there.
Sentence hearing part.
Yeah. It's not there.
Yeah.
It's not there, my lord.
Let's see. Let's see more to ask, brother. Anything else to ask? No.
The prayer petition also, at page 82, nothing has been cited by him. It's from the jail, my lord. I Ottawa Munda, so and so, I'm a poor person and earn my livelihood by working on daily basis. For end of justice, Lordship may direct the district legal services authority to verify if any.
In the judgment,
Yes.
Yes.
That
in
can be
judgment.
looked into.
irrespective of the outcome.
Lordship.
Mr. A. Tiwari, learned amicus curiae for the appellant. And Ms. B. Bhuyan, learned additional public prosecutor asset for the state. Hearing concluded, judgment reserved.
Deeply obliged, Your Honor.
Yes.
May I please amend? Lordship, this matter solely depending on the oral dying declaration. my lord.
302.
Lordship,
302.
yes. 302. So, and whatever this PWs are there, no one is there regarding eyewitnesses. No eyewitnesses are there. Not a single person. And Lordship, kindly comes the FIR, Lordship, page 14, Lordship.
Just a minute, huh?
The relevant portion, my lord.
Page 15.
14 in my appeal, my lord.
No, you come to you don't have the paper book.
Yes.
Let us use the paper book.
Then the page, relevant page will be 4, Lordship. May I read, Lordship?
Yes.
The officer in charge, Digbo police station, so and so as our, that is 17/9/2016. Sir, madam, with due respect, I beg to state that at about 10 o'clock in the night on 16/9/2016, Sri Deepak Thapa, son of resident of Kherjan village, came to Krishna Bahadur's house in the same village and woke up Krishna Bahadur from his sleep and took him to nearby Dhekyajan village for some reason. A little later, Sri Leela Chetri, a resident of Dhekyajan, who had been lying in ambush on the road, assaulted Krishna Bahadur, thereby injuring him seriously. Thereafter, 108 was called and Krishna Thapa was admitted in IOC medical at Digboi. However, Krishna Bahadur Thapa died while under treatment. Here, I would like to point out the informant is Milan Thapa, man. Here, my lord, I would like to point out. Number one, there are two name accused, my lord. One is Deepak Thapa. Another is this appellant Leela Chetri. But at the time of submitting the charge sheet, the Deepak Thapa was exonerated. And Deepak Thapa is not in the scene either as witness or anything else. And as per the FIR, it is specifically said that he woke up the victim and they come together to the spot. But he is not in the scene, Deepak Thapa.
When was he exonerated?
Yes.
Before
Lordship.
before filing of charge sheet?
Yes, it is. Number two, my lord, time I would like to say in the FIR itself. In the FIR, secondly, my lord, nothing has been mentioned about the dying declaration in the FIR. There is our High Court's decision, my lord, regarding this. Nothing has been mentioned about dying declaration in the FIR. Hence, it is afterthought and a manufactured one.
It should be mentioned as per the High Court decision.
Yes, it is there, my lord. The High Court decision said that when there is a lacking of the dying declaration in the FIR, it cannot be treated as the it says just I'm reading forward. Does the facts that there was no mention about the dying declaration in the FIR, though the PW4, the informant claimed to be a witness to oral dying declaration made before him immediately after the occurrence, that the identity of the assailant have not been page number so and so established as admittedly there were at least 4 persons in the village having the same name, that is Nijamuddin so and so, mentioning the name of a different Nijamuddin specifically in the FIR as perpetrator of the offense, and the recording of Exhibit 3 and Exhibit 5 dying declaration by PW5 and PW6 respectively under the suspicious circumstances as indicated above demonstrate that the so-called dying declaration, both oral as well documentary, relied by the learned trial court was not free from blemish and shrouded in suspicion, and as such, in our considered view, conviction could not have been based solely on the basis of such dying declaration, which were evidently not free from suspicion without corroboration from the other independent witnesses. Needless to mention that there was no other independent evidence to bring in aid of the dying declaration. We are therefore of the considered opinion that conviction and sentence of the appellant solely on the basis of the aforesaid dying declaration, which were not free from suspicion, cannot be sustained. Therefore, the appellant in the instant case is at least entitled to the benefit of doubt. Accordingly, we set aside the conviction and sentence and allow the appeal. The appellant, if in custody, shall be released. If not, if got in any other case. That part. Here also, Lordship will find the same fact. Now,
can you give us the citation? What is that?
Yes.
Since you just read it.
I will ask.
Oh, you have a copy?
Yes, I have.
So you can give it later, give me the citation.
Yes, you can give us a citation now.
Yes. Yes. This is regarding Nijamuddin Sheikh Manat, criminal appeal number so and so. It was decided in 2021 by our High Court, Manat. And page para 20,
Is it reported anywhere?
I have not seen, my lord, para 20, my lord. I have to check, my lord. Para 20, the 3 Supreme Court judgments were relied on. Para 20. The Apex Court in Nanhar versus State of Haryana, 2010-11 SEC 423 held that the dying declaration should be such which should immediately strike to be genuine and stating the true story of its maker. It should be free from all doubt and ongoing through it. An impression has to be registered immediately in mind. It is genuine, true, and not tainted with doubt. In 21, instead of UP versus Ram Sapar Yadav, 1985 1 SSC 552, the court held that if the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. In Rasek Peg versus State of MP 1974 4 SCC 264, the Supreme Court held that where the dying declaration is suspicious, it should not be acted upon without corroborative evidence. And 23, in Ram Manorat versus State of UP 1981 2 SCC 654, the Supreme Court observed, page number so that a dying declaration which suffers from infirmity cannot form the basis of conviction. That part, my lord, and 26, my lord, para 26, para 26. The PW5 deposed that he recorded the Exhibit 3 dying declaration in presence of CW2. However, what is evident from the oral testimony of the CW2 is that the Exhibit 3 dying declaration was not recorded in his presence, and his signature on Exhibit 3 dying declaration was obtained later on when the investigation officer collected the Exhibit 3 from the doctor. Thus, the testimony of CW2 appears to be contradictory to the evidence of PW5, who deposed to have recorded the dying declaration in presence of CW2. Learned trial court, though, ignored the testimony of CW2, who as an official witness. No reason, however, has been shown for ignoring the testimony of CW2. According to CW2, he went to the medical college and also issued a requisition to the superintendent of the medical college hospital for recording the dying declaration of the victim. However, it is in evidence of PW5 that he did not receive any requisition for recording the dying declaration, and he decided to pay so record the dying declaration in his own wisdom, having noticed the serious condition of the victim who sustained burn injuries, meaning thereby the superintendent of hospital to whom requisition was given for recording dying declaration did not instruct the PW5 for recording dying declaration. Apparently, the doctor has not appended any certificate to the Exhibit 3 with regard to the fitness of the victim to make the dying declaration, which is also in the similar nature in the present case. We are aware of the fact that absence of the certificate with regard to the fitness of the victim to make the dying declaration per se shall not render the dying declaration unreliable. But when the other evidence on record and attending circumstances raised doubt as to the fitness of the victim to make the dying declaration, absence of fitness certificate certainly erode the credibility of the dying declaration, or at least raises a doubt as to the fitness of person making the dying declaration, particularly when the dying declaration is otherwise also not free from blemish. Now, my lord, I will go to the charge sheet, my lord, and my lord, this in the FIR, it has also been said that he was taken to the IUC hospital, and during treatment he has expired. But at the time of the trial, my lord, this IUC hospital's doctor has not been called for, and meaning thereby this accused has been deprived of getting opportunity to get defense.
Okay, let us
This
proceed.
judgment is also there, my lord.
Let us proceed with the
Yes, yes.
facts first.
Yes.
Then you come to your submission later.
Now, lordship will find the
Charge was framed
lordship.
as per page number 6.
Yes. Charge sheet, lordship. Page number 6, lordship.
Framing of charge.
19/5/17, my lord. It will be. Oh, charge sheet will be. Oh, sorry. 6. On or about on or about 16/9/2016 around 10 p.m. at the Hekiazan Gaon under Digboi PS had committed murder by causing the death of Sri Krishna Bahadur Thapa, and that committed offense punishable under section 302 IPC and the cognizant this court. And I hereby correct me that you be tried in the court of the undersigned in the right.
Okay.
Right.
Okay.
Charges under section
302.
Lastly, lordship.
302. Then let us proceed to, it was committed thereafter the trial began. Let us start from PW1.
Yes.
Who is PW1?
Yes. PW1.
The uncle of the deceased.
I see.
The informant, my lord. PW1.
Informant. Yes.
Comment as well as uncle.
Please read.
Yes.
Deepak Thapa was not sent up for trial.
No. Deepak Thapa was there in the FIR, so, but he has been exonerated.
Where is the charge sheet? Name is not there. When was he?
Lordship will find from 91 itself, my lord. No?
89 of right, Josh.
It starts from 89.
Deepak Thapa.
Yes.
Only was that. They lost of the one.
It says not sent up. Names and address of accused person not sent up for trial. Complainant's name is there, not sent up is there, then name sent up is there. Leela Chetri, the appellant. So that's it. And what more can we see?
Yes.
Was not sent up, not sent up. PW1 is the uncle.
PW1.
Informant.
Informant.
Say Milan Thapa, my lord. May I read, lordship?
Yes.
I'm the informant of this case. I know accused Leela Chetri. This is Krishna Bahadur Thapa is my nephew. The incident occurred about 2 years ago. The incident occurred at around 8-9 p.m. Whereas in his Azhar it was 10 p.m. Here it is 8 or 9 p.m. On 16/9/2016. I was present at home at the time of incident. Krishna Bahadur's house is about 100 to 150 meters away from my house. While I was at home, I heard a commotion that Krishna was assaulted by Leela Chetri. As I rushed to the spot, I saw Krishna lying on the road in an injured state about half a kilometer away from my house. When I asked him, Krishna replied that Leela had assaulted him. Lordship, kindly, but his voice died down after death. My elder brother Dhan Bahadur Thapa, Dil Bahadur Thapa, Lok Bahadur Thapa, and several other persons were there near Krishna before he reached my lord. Their elder brother Dhan Bahadur Thapa, Dil Bahadur Thapa, Lok Bahadur Thapa were there. They were they arrived. This person arrived earlier to Milan Thapa. It is very important, my lord. And none of this PW says anything, my lord, regarding this dying declaration. accept this information.
Are they examined as wish?
Yes, yes.
with
My lord,
prosecution
I'm
witness?
coming, my lord.
No, no, just that, whether they are prosecution witness or not.
Here, Dil Bahadur Thapa has been examined.
Dil Bahadur is
PW2.
PW2. Then, no, Dhan Bahadur is,
And Lok Bahadur is,
Dhan Bahadur is not there.
Dhan Bahadur is the father, my lord.
No, he is not there in the, amongst the prosecution.
No, no,
witness.
And Lok Bahadur is that PW3. They arrived earlier to the informant, my lord.
2 and 3 are there, but Dhan Bahadur is not there, isn't it?
Yes,
Amongst the examined prosecution witnesses,
yes, Dhan Bahadur,
is not there.
he has not been examined.
Dil Bahadur and Lok Bahadur.
Only Lok Bahadur has been, Lok Bahadur and Dil Bahadur has been examined.
Then,
Now, my elder brother, Dhan Bahadur Thapa, Dil Bahadur Thapa, Lok Bahadur Thapa, and several other persons were there near Krishna, the deceased.
hmm,
We took Krishna to IOC hospital in 108. All of them.
hmm,
The doctor declared him dead.
hmm.
Letter says, I did not go to the hospital. Dil Bahadur Thapa took him to the hospital. I went to the police station in the night itself. I was told to come to the police station the following morning. However, I lost the Azhar on the night of the incident itself. Exhibit 2 is the Azhar lost by me, and Exhibit 2.1 is my signature therein. Police performed post-mortem examination on the dead body of Krishna. I went to Tinsukia with the dead body. So and so is my signature on the inquest report. In the cross-examination, my lord, the scribe's name is not mentioned in the Azhar. Yes. The Azhar was read out to me. I did not state to police where the accused got injured. They did not say. I did not state to police regarding source from where I got the information. I had gone out of the house when I had heard the commotion. He heard it. He has not seen it. I had not witnessed Krishna being assaulted by the accused. It is not a fact that I did not state to police that Krishna had uttered the name of Leela. It is not a fact that I did not mention to police the details regarding the house of the accused and the spot where Krishna had been lying. It is not a fact that I did not state about seeing Dhan Bahadur, Lil Bahadur, and Lok Bahadur near Krishna Bahadur. It is not a fact that I have adduced the false evidence as Krishna Thapa is my relative. That his cross-examination, it will be clarify that what he has stated or not, whether he has stated or not, the IO will be, either IO has clarified in his deposition. Now I will come to the next PW2. Dil Bahadur Thapa. I know informant Milan Thapa accused Leela Chetri and this is Krishna Bahadur Thapa. Krishna Bahadur Thapa is my paternal uncle's father's elder brother, the elder brother's son. The date of the incident was 16th and the year was 2016. I do not remember the month. The time of the incident is around 9 or 10 o'clock at night. At that time, I was studying at home. At that moment, my friend Vishal Pradhan informed me over phone that Krishna Bahadur Thapa had been beaten up and was thrown on the road. And who is beaten up, it is not said. I went to the place of occurrence, which was about 1 kilometer away from my house. I went to the spot and saw Krishna Thapa lying in an injured state. He had sustained head injury. There was little bleeding from his nose and mouth. Krishna was alive at that time, but was not able to speak. He was speechless, my lord. When I had reached the spot, I found my brother Himalaya there. Himalaya, his brother. Only the Himalaya was there as a first witness to see it in the first in the occurrence. And secondly, this Dil Bahadur Thapa came. Dil Bahadur came, my lord. The PW2 first he came, and before him, the Himalaya was there.
Himalaya is the brother of this
That's
PW2.
Yes,
They
PW2.
are brothers. They are
Oh, yes.
brothers.
Elder brother, I do not know, my lord. Only it has been said brother.
Otherwise, PW2 is the cousin of the deceased.
Yes.
Fathers are related.
Now, and he has not said anything about the dying declaration. And
He was unable to speak.
yes, unable to speak.
He didn't say anything.
Yes,
He was unable to speak.
unable to speak.
Okay.
And how the subsequent person who came in the informant came later on, how can he say that the dying declaration was given?
So did he come subsequently or because
No, he came subsequently.
because
The
they
informant.
PW wanted a statement that
8 to 9 p.m. whereas PW talked to 9 to 10 o'clock.
I know.
PW1 states that
8 to 9
after saying that Lila assaulted him, his voice died down.
Yes.
So if he has come later, then it might be compatible with this. Otherwise, anyway.
So who came first?
As per the FR, it is 10 p.m.
Okay.
The timing is 10 p.m. as per the FIR.
10 p.m. FIR, but PW1 says 8 to 9.
To 9.
PW2 says 9 to 10.
9 to 10. Everybody's.
But
now I'm
when PW2 went around 9 to 10, only Himalaya was there.
Yes.
Afterwards, when
No.
PW1 later on,
Yes.
there were 3 people there. Dhan Bahadur, Dil Bahadur and Lok Bahadur.
Because incident occurred at 10 p.m.
There's no mention about the Himalaya by the PW1.
Exactly.
Correct. But all of them seems to have gone there.
Now Lordship will find when I had reached the spot, I found my brother Himalaya there. Thereafter, the villagers also arrived there. Subsequently, villagers came.
Himalaya is a pet name or what?
My lord,
Himalaya is the other name of any of these. Dhan Bahadur, Dil Bahadur, or Lok
I do
Bahadur.
not know, my lord. That maybe someone others, my
Okay.
lord. He has not been examined. He has not been called for witness, my lord.
Then
Thereafter, the villagers also arrived there. We call 108. My lord, here no question of taking any oral dying declaration, my lord, by this PW2. Immediately they had taken to the 108 ambulance service and took Krishna to the IOC hospital. Krishna died there. We lodged a complaint with the police station in the night of the incident. On the following day, the incident police recovered the bamboo stick which was used by the accused to beat up the Krishna. Well, it is on the following day of the incident, the police recovered the bamboo stick which was used by the accused to beat up Krishna in the house of the accused. He says house of the accused, but IO says it is place of occurrence.
IO is PW?
IO is PW8 money. PW9. 8-9 meeting. Yes. IO, PW8 says it was place of occurrence. It was recovered at place of occurrence. Now, I will go by the PW's first minute. Now, on the following day, the incident police recovered the bamboo stick, which was used by the accused to beat up Krishna in the house of accused. The accused caused the death of Krishna by beating him up with the bamboo stick. The distance between the spot where Krishna was lying and the house of the accused is approximately 100 meters. cross, I do not remember whether I stated to police that Vishal Pradhan had informed me about the incident. It is not a fact that I stated to police that I was informed about the incident by Rudra Chetri. It is not a fact that I did not state to police that I saw Krishna in an injured state. I do not remember the phone number of Vishal Pradhan. I did not witness the person who had injured Krishna, my lord. He is also not eyewitness, my lord. It is not a fact that I have made false statement as Krishna Thapa is my relative. It is not a fact that I have made false statement regarding the recovery of the bamboo stick used in the incident from the house of the accused. According to him, the bamboo stick was recovered from the house of the accused as per the PW2. Now, now Lordship will come to the PW3, my lord.
Lok Bahadur.
Lok Bahadur Thapa, my lord.
He was also there.
He was also there,
As
but
per PW1.
prior to the PW1.
He's also again cousin.
Yes, madam. Married, Lordship. I know the informant Milan Thapa accused Leela Chetri, and this is Krishna Thapa. Krishna Thapa is my maternal uncle's son. The incident occurred about 1.5 years or 2 years ago. The incident took place at about 9 p.m. one day. At the time of incident, I was at home when Dil Bahadur Thapa came to my house and informed me that Leela Chetri had assaulted to death Krishna following a quarrel. I then went out with Dil Bahadur. Dil Bahadur is PW2, my lord. The spot where Krishna Bahadur was lying. I saw Krishna lying in an injured state on a road near a road junction about half kilometer away from my house. He was not able to speak, my lord. Here also PW3 also said he was not able to speak. 2 and 3 said who came earlier than the PW1, they said that he was not able to speak. Due to darkness of the night, I could not see where on his body he had sustained injury. Later, Dil Bahadur called 108 and took Krishna to IOC Hospital, Digboi. And from the hospital, Dil Bahadur informed me over phone that Krishna had died. Thereafter, and this is also contradicted by the IO, saying that on the way to the hospital, he died en road, not in the hospital. Anyway, Dil Bahadur informed me over phone that Krishna had died. Thereafter, I went to the hospital by motorcycle. My maternal uncle Milan Thapa lodged an azahar with the police station on the night of the incident itself. From what I heard, the accused had beaten up Krishna, dragged him away from his home, and thrown him onto the road. Although police went to the house of the accused during the night, the accused was on the run. I came to know that on the next day, police recovered the bamboo stick used in the incident from the house of the accused. He also says from the house of the accused, the bamboo was recovered. 2 and 3. They say that bamboo has been recovered from the house of the accused. And police brought the said bamboo stick to the police station. And thereafter, I put my signature on the seizure list in the police station. Exhibit 3 is the seizure list, and Exhibit 3 is my signature therein. Exhibit 2, inquest report, and so and so, so and so. Now, in the cross, it is not a fact that I did not state to police that it was Dil Bahadur who had first informed me about the incident. I did not state to police that Krishna had been beaten up by Leela at his home. and I was thrown on the road. I put my signature exhibit 3, the seizure list, in the police station. I did not witness the place from where police had recovered the bamboo stick. And so he is not a seizure witness. I did not witness the person who had killed the Krishna. It is not a fact that I have adduced false evidence. Now, another PW4. This is Anil Thapa, my lord.
Deepak Thapa was not made a prosecution witness also, right? He
Yes.
was not.
No.
But you were only eyewitness.
Yeah, he said he had, police had brought the recovered bamboo stick from the house of the accused and brought it to the police station, where he became the seizure witness. So that's why he said he did not see from where exactly they brought.
That's it.
On the police station only, he saw the stick, so he said that I'm the seizure witness.
And so this statement, they're saying that it is collected from the house of the accused, is totally false. Now, PW4, my lord. The Anil Thapa. All Thapas are here, my lord.
All family thing. Milan Thapa is my own younger brother.
Anil Thapa is PW4.
One Chetri is also there, PW7.
And the Leela Chetri is a victim, is Chetri, my lord. Anyway, my lord.
Milan Thapa is PW1.
Now,
PW4 is the elder brother of PW1.
Yes, yes. Yes. Informant Milan Thapa is my own younger brother. That is Anil Thapa is the elder brother. I know accused Leela Chetri present in the dock. This is Krishna Bahadur Thapa was my nephew. About 2 years ago, while I was at home, I overheard a commotion in the village in the evening hours that Leela had killed Krishna. Thereafter, I saw Krishna Bahadur Thapa lying near Leela's home by the side of a road, which leads to Palalua Gaon. When we call him, although he could not respond, he was breathing. He is also saying that he could not respond. And whatever the statement has been made by the PW1, all are suspicious. 2, 3, 4, they are saying that he could not speak. He could not respond. He was just breathing. The 108 ambulance arrived approximately half an hour after I had reached the spot, and he was taken in that ambulance. I did not see any injury. Later, we also went to the hospital and doctor pronounced him dead. We went to IOC hospital, Digboi. Police came to the hospital. Police took my brother Dil Bahadur and me to the police station. I was questioned. Police went to the place of occurrence next morning. I was also called to the place of occurrence. Leela's wife gave a long bamboo stick to the police, stating it as the murder weapon. This accused wife has given a long stick. Leela's wife means that is accused. Accused wife gave a long bamboo stick to the police, stating it as the murder weapon. Police took away that bamboo and took my signature. Exhibit 3 is seizure list, so and so, so and so. Now, 3.2 is my signature. Police examined the dead body in the hospital, so and so. Exhibit 2 is the inquest report, so and so. Is my signature. When I reached the place of occurrence, the accused was not there. He was on the run. Now, cross-examined, police questioned me regarding the incident. I did not state to the police that when I had reached the place of occurrence, Leela was not there and was on the run. I did not witness the incident myself. He did not see it. He is not the eyewitness. I only learned about it through hearsay. I put my signature, exhibit 3(2) in the police station. There were other people in the police station. When I was putting my signature, when I signed on exhibit 3, something was written on it. Thereafter, I put my signature. I saw the bamboo stick at the place of occurrence itself. Now he said something else. I saw the bamboo stick at the place of occurrence itself. It is not a fact that I have stated falsely that I witnessed Leela's wife producing bamboo stick. It is not a fact that I have made false statement in examination chief. It is not a fact that as the deceased is my relative, I have made false statement. This 2, 3, 4. They are saying that he was lying. He could not respond at that moment.
But that bamboo stick was correctly said.
No, no.
because-
Now bamboo stick.
No, he was called by the police next morning to the house of Leela. And wife of Leela handed over the bamboo stick to the police.
He said it.
So he also saw it. He said, I saw the bamboo stick at the place of the occurrence itself.
The accused wife, will it be possible to imagine, my lord, that the wife is saying that yes, this is the bamboo by which my husband killed the person.
Are they related? The deceased and the accused?
That's it.
Are they related?
No.
Accused and the deceased? They are not related.
No. Oh, who accused and the
Deceased.
Houston, the deceased.
They're relative.
No. He is Thapa and he is Chetri.
This is Chetri.
Yes, this is Chetri.
No.
Thapa. This is Thapa.
This is Thapa.
Thapa. Krishnabadu Thapa.
And
Victim is
okay.
Victim is Thapa.
Leela is Chetri. I mean, the accused is Chetri.
Chetri, no. Brahman Khetri hoya.
Chitri-
OBC.
And if the bamboo stick was seen at the place of occurrence, and thereafter it was seized from the house of the accused. That means after the alleged offense, he brought back the bamboo stick.
I don't know, my lord, all this discrepancies, my lord. Now, Lordship will find the clarification in the IOS report, IOS deposition, my lord. So let us go for Indra Bahadur Thapa's PW5.
What is his role? Indra Bahadur? He was not there.
PW5. He also said he did not see the incident. Informant Milan Thapa, may I read, Lordship?
He's my youngest paternal uncle. Informant is youngest paternal uncle. Okay. He's the nephew of the informant.
Milan Thapa is my youngest paternal uncle, father's youngest brother. I know accused Leela Chetri present in the dock. This is Krishna Bahadur Chetri is my eldest paternal uncle's son, that is cousin. One morning about everyone are relative to the Krishna Bahadur Marat. One morning about 1.5 years ago, informant Milan Thapa informed me over phone that Krishna Bahadur was in the IOC medical. Milan told me that a quarrel had taken place between Krishna and Leela. Thereafter, I went to the IOC medical, and I was told that he was dead. I went to the police station from the medical. I was questioned by police. Exhibit 3 is the seizure list. Exhibit 3 is my signature. I did not witness the quarrel. He did not witness the quarrel. I did not state to police that Milan Thapa informed regarding the incident over phone. I did not witness myself where and how the incident occurred. I put my signature on exhibit 3 in the police station itself. I do not remember it now whether there was something written on exhibit 3 or not. I do not know what is written on exhibit 3. I'm illiterate. It is not a fact that as this is my relative, I have adduced false evidence today for his sake. This is Indra Bahadur. Now, the deposition of PW6, my lord. PW6 is a medical officer.
Just a minute. Sir. Have single bench. I think we'll have to continue tomorrow.
Lots.
My brother has a single bench only. Oh. So.
Then lots of.
But then it will be subject to time. Tomorrow, we have one more part. This will be the second part.
Lots.
Let's see.
Two hearing matters will be getting adjourned. Tomorrow's. Thank you.
Lordship will pass the order regarding part of. Tomorrow it will be listed.
Of course, it will be part.
Yes.
And I hope we can complete tomorrow.
Yes.
Single bench. We'll see what to do. Since we have spent some time, let's see if we can.
It will not take more time tomorrow, my lord.
I'm told there's a single bench
Yes.
for me and maybe, I don't know, perhaps brother also must have.
At least for tomorrow, lordship's bench will continue so that the whatever the part out will be, that will be completed. Will be obliged otherwise. Because again, matter will be pending for some. And he is suffering, my lord.
Okay, please write hard it part.
Yes.
This is the matter again tomorrow.
Much obliged.
Also, I beg to mention regarding item number 7 of today's list, this matter, he was convicted for 12 years. He already undergone about 4 years, and because of the reason today was fixed. So may I pray this matter will be fixed on Monday, Lordship? He was kept as under trial, Lordship, so he is already undergone about 4 years.
Who's for the other side?
For the state and.
State is there. Informant. On Monday, Lordship. He's already undergone about 4 years.
They praised IA, court was not inclined to grant.
Ultimately, that was withdrawn and accordingly this matter was fixed today. This is a
Withdrawn
fixed item.
because court did not incline to pass
Yes,
order
sir.
in your
Yeah.
favor.
Whatever order will pass, that is a different aspect. So I am not married of the case at this stage. The Lordship will hear and decide. So only for that I am praying for fixing on Monday, Lordship.
That's great for by the parties, this matter on 17. February 2026.
All right.
What about item 8?
In 8, Lordship, I am appearing, but Lordship will fix a date or registry will fix there.
You are there?
Yes, your lordship.
For which pardon?
Lordship, I'm for the complainant, informant, your lordship.
Have it in the month of March.
Lordship,
Registry will give a date.
lordship.
Yeah.
First week of March, Lordship.
That's right. What is the month of March 2026 on a date to be fixed by.
All right.
Highly obliged.